Yes, Mr. Das.
518 connected to item number 83. In 18 you have serious download.
If it reaches here, till bails are over. Yes.
I paid to listen of an unsaid matter on Monday, it's the 20th,
Matter pertains to
it is a personal appearance on 30th on Honorable Chief Judicial Magistrate Court. And this matter is purely a commercial dispute.
no, understand matter pertains to what? So you make a mention before the senior bench. Except bail up to 7 years. Here mention is here for listing. Others you go to the senior bench. What are which court?
Court number 9.
Court number 9. You make a mention there. Yes. Why? Yesterday there is a judgment from the Honorable Apex Court, Kothakot. Relying on earlier judgment said that no need to appoint amicus, on merit revision can be disposed of. Now that is the handle for me. I will not wait for anybody. We cannot fix this as per your convenience. Yes, no. Where is your circulation that you have taken consent from the office? Then, without circulation, we are not adjourned. Refuse. Prayer is refused. Repeat it when matter is yes. Yes. Item number 14. For bail. Have you filed it? Bring it today. You want to bring it today? Yes, give the list. Give the list. Give the number and mention number or slip. Yes. What is this WPC criminal, sir? Okay.
The FIR was there in the initial stage. Subsequently, charge doesn't file. So again, we have filed an amendment petition for filing of the charge sheet. And now this order of paying for has not been generated. So again, amendment will make instead we want to file the file.
Okay. The learned counsel for the petitioner submits that these applications are defective. Accordingly, you wants to withdraw the same and file afresh a proper application. Accordingly, this petitions 39, 40, and 41 stands dismissed on withdrawal with a liberty to file afresh.
42,
39 to 42. Yes.
Yes.
50. 52. What is the matter about? Have you circulated the adjournment? We are rejected. Yes. Is there any interim order? So you have no objection?
No, we have not have objection. Just we want them to search the copy.
Okay, the learned counsel for the respondent submits that though they have entered appearance, they have not received the copy of the criminal revision petition. Accordingly, the learned counsel for the petitioner is directed to serve a copy during the course of the day and matter be during the course of the day to the learned counsel for the respondent, isn't it? List this matter when 3 weeks. List this matter after 3 weeks on a date to be fixed by registry. Yes, interim order pass earlier shall continue. Mr. Das, we want to dispose it of things. Nobody is interested. Either petitioner or respondent. Even if stay is there,
Motion B, item number 1.
yes. Mr. Das seems Bothakur seems he is a psychiatric patient. To the satisfaction of with a condition that he will not go near the house of the informant. Huh?
Number 2.
Yes. So CCTV sees he was seen. How many days? Huh? 20 days. To satisfaction of whom? First class Boko.
Item 3.
Yes, Mr. Bothakur, it's a case of quashing. It's a case of quashing. Is it a way state files affair? Whatsoever, is it a case? It's a case of quashing. Read the affair. How many days? Only 7 days. You have also done something. But is then on the basis of affair, a person cannot be put behind bars.
Otherwise, what kind of surveillance activity?
Whatsoever. What is the allegation? What will be the investigated? See the allegation. To the satisfaction of, ask them to file proper FIR. CGM Kamrup 25,000.
Motion AB, item number 4.
Yes. She is also having psychiatric problem. Have you seen the thing? She wants to be the deputy commissioner. She is a video. She comes and says that I should be the made deputy commissioner. And she has been under treatment since long. Depression and thing. Interim. CD interim. You give your statement and ask your client to have the medicine regularly. Most probably stop medicine, then thought, why should I be BDO? I should be DC. Isn't it? So ask your client to have medicine.
So motion item 5.
Yes. Yes. What is the ground?
The incident took place at Rampur district minor.
Yes.
So as per section 177 minor,
Mm.
trials to be something the jurisdiction of the court where the offense is committed minor.
Yes.
Number 2 minor, all the petitioners are women minor.
Mm.
There is no male member in the family minor.
Mm.
So there is already dispute in their matters. Husband and wife dispute mainly minor. And they have a son matter.
Who are the petitioners?
Petitioners are my mother and 2 daughters. Number 3 is the wife of the complainant minor.
Number 3
Number
is
3 is the wife of the complainant.
complainant.
And number 1 is the mother.
What is the complaint of? This is filed by the complaint filed by the husband against his mother-in-law, sister-in-law, and wife. And the offense committed where?
Rampur, Kolaswari.
And where this application complaint is filed? Where this complaint is filed? Heard, Mr. Mukhtar, Learned Counsel for the petitioner. The present application under section 405 of the Code of Criminal Procedure 1973 is filed for transfer of CR case number 52/2023 under section 294/323 44 pending in the court of the Learned Judicial Magistrate First Class Golaghat, Assam. Mr. Mukhtar challenges seeks transfer basically on the ground that admittedly the alleged incident took place at Rampur in the district of Kamrup, whereas the FIR, the complaint has been filed by the respondent at Golaghat, in as much as no inquiry under section 202. Yes, 202 or 200. Some inquiry is required when it's outside the jurisdiction. Okay. The inquiry required under the Code of Criminal Procedure has not been done before taking the cognizance. Full stop. This matter needs further consideration. Accordingly, issue notice returnable after 6 weeks. Mosumi, returnable on 13th of October. Full stop. Considering the nature and gravity of the offense, as well as the arguments of Mr. Mukhtar, this court is of the view that the petitioners have been able to make out a case for an interim protection. Accordingly, it is provided that till the returnable, that further proceeding of so and so pending before so and so remains suspended.
Item 6.
None appears for the petitioner. Keep for some time.
Item
This is
7.
the application I was called for. Okay. Heard Mr. Swenso, Learned Counsel for the petitioner. This is an application under Swenso, assailing Sailaga. Swenso issue notice returnable after 6 weeks. Mr. Bothakur accepts notice on behalf of respondent number 1. Any informant?
Yes.
Steps to respondent number 2. Both ways within 5 days. Considering the nature and nature of the offense, as much as the period of sentence, the till disposal of the connected criminal revision petition, the impugned judgment 23/5/23 passed by Jorhat shall remain suspended. And judgment and order dated 10/6/20/2022 passed by Lalit Sijan Jorhat shall remain suspended. No, shall remain suspended. The petitioner is allowed to remain on previous bail in connection with these two judgments. I disposed of.
Item number 8.
Last season, there were 2 queries from the court.
Yes.
Whether the license was renewed or with 30 with 30 renewed with 5 together. Some what has happened. With 34, I'll just explain. This is the photograph. This is a photograph uploaded in the Facebook account. He was the driver of the owner where I'm in the PSO. Lordship, I kept my palms in the dashboard after rubbing it with a wet cloth. We put sindoor during puja. Therefore, he took the paper and clicked a photograph and uploaded in Facebook. After some days, he's attended in a
How you can be appointed as a PSO? What is the procedure of private PSOs?
No, Lordship, I am a Indian Army personnel, short service retired. Thereafter, Lordship, page 36, Lordship, my agreement. Page 36, with the director of the Sarda Kurobi Nidhi Limited Bank.
No, no. Page 34.
Page 34 is the photograph, 36 is the agreement. Page 35, page 34, yes, and page 35, Lordship would see the second party was working in Indian Army in the capacity of Havaldar and having security training certificate issued by Indian Army certificate.
Now tell us that an Indian Army person after retirement can work as a PSO with a gun. Who will give the permission, Mr. Bottakor? Can any army person come and have a license and then I will be bodyguard? How can that be? If you are having a security concern, file an application before the DGP or whose concerned officer.
And from the investigation, status report of the IO, already my lord, they are from cancellation of that license, already my lord. Licenses is very. Firstly, I am nowhere related with the offense. They did an NDPS offense after leaving the owner.
No, forget about the NDPS offense. We are not on, we agree. We are not connected with the NDPS offense. What is the allegation in FIR? Tell us.
What is allegation in the FIR is that 3 persons were apprehended with 3.12 grams heroin
From where?
from hockey stadium.
Okay.
Near hockey stadium. Thereafter, these persons named the driver that he was also connected. Therefore, after leaving my owner, he was arrested in an offense under NDPS. When there was a background check of that person into Mr. I am Bonful Lekha. Then this photograph was found out at his DP. Therefore, when further investigation was made, it was found that these arms belong to me. And how he clicked the photograph, I have already explained.
No, forget about the photo. Now, the gun is seized.
Yes.
Let us see the license first.
Yes. And in the serial memo, it is strongly recorded. The validity of the license is up to 6 March 2017 to 5th of March 2020. As per report of 2023.
Yes.
Renewal is strongly recorded. Renewal is page 30.
We are not interested in giving Zimma of guns. We are interested in giving Zimma of vehicle who is running their day-to-day life with the
What has happened, I'll tell you.
betel
Now,
nut,
it is my livelihood.
not gun.
No, it is my livelihood, but I will kindly explain. Because I am not having that gun, it is still, I have been paid half of my salary. I have been paid half more of my salary because of now I have
No, tell us under what authority a person can have a gun license. I have no issue on that. I might have a gun with a license, no
Yes.
problem on that.
Yes.
But to be a PSO of somebody, there must be some authority of law. Anybody
Yes, yes.
cannot take the gun.
That is the army training
So
certificate.
show us that an army man can automatically become private PSO with a licensed gun.
Yes, Lord, so that today I don't have, but.
So you show that
And also-
you satisfy is that this is your livelihood and you are authorized under law to have a gun and to get appointed as a PSO to protect somebody else. Though there are provisions under law that an individual can apply for a PSO in a given condition when his life is under threat. And considering each and every case, the facts of each and every case, a state may protect you, give you a PSO, or that may be withdrawn also in a subsequent event.
Yes, yes,
So therefore, you will have to satisfy us
yes.
that an army man under this authority of law is having a vested right to be a PSO of a person with a gun in his hand, having a licensed gun. That will satisfy us.
He is a government official. Private agreement between the parties.
That is why you show us the authority
Yes, sir.
to be a PSO.
Yes.
If we allow this kind of things, if there is no authority of law, then everybody will come and say that, oh, he is a retired army. have a like gun and be my PSO. I do not think that is the law.
I'll satisfy your law.
You satisfy when?
We did nothing.
Yes, give us that. This is my query. If you can satisfy that this is a livelihood, your livelihood and authorized under law, I will give you the gun.
Yes, sir. Definitely.
Let him have a satisfaction. Let him have his satisfaction.
Lordship will kindly allow me to file an affidavit on these 2 points.
Yes, you file an affidavit, Mr. B.
Yes, ambiguous case diary is not clear. I may be allowed to return that the case diary. Only my
On a very short deadline.
Okay, on the prayer of the learned counsel for the petitioner, Mr. Counsel petitioner, Madras states adjourned, enabling him to file an additional affidavit to show the authority of law under which the petitioner was allegedly appointed as a PSO, having his gun and gun license. You show us that, Bhattakur, you see the procedure, because I think there is a definite SOP for appointment of PSO and who can be PSO. If the private persons are, maybe army officers may be granted, there may be authority, but where is that? We want to see. Show us, make us satisfied, we will pass the 13.9. Whatever you can give the case diary, or can you take it back till 13th is a long date. Investigation will be stalled.
Status report is sufficient.
So okay, we should give back this.
I will return that.
Want to see it? You have the status report. Yes.
Item 9,
Notice agar order to the receiver. Give the judgments. This is an application under suspension. Even the stage. Like item number 7. What is the period? 3 months. 3 months.
6 months.
6 months. IA disposal. In criminal revision notice, IA disposal. Similar like the earlier order. Item number 7. Okay. In that case, 3 months. In this case, 6 months. Yes. Yes. Previous bill. Yes. You give the 2 judgments. But be ready on admission. Will hear it. Call for the LCR. Issue notice. Call for the LCR.
timing item 6.
Yes.
Supposed to file an additional affidavit.
Ah.
Filed it yesterday.
That is not on record.
Yes, sir. Yesterday I have filed.
So what to do? Monday? Or-
I'll be out of it. Maybe any date, maybe on Friday, next Friday.
Next Friday. It is submitted by Land Council for the petitioner that an additional affidavit has already been filed. Same is not on record. Registry to release this matter on next Friday will be
First of September.
1st of September, along with the additional affidavits stated to have been filed.
Bail hearing BA, item number 16.
Yes, Muni.
The PAN card. The 50 days.
PAN card that Ram,
Yeah,
main we have given. To the satisfaction of
CGM
CGM Kamrup.
one of the main.
One of the, but the main we have given. And this main. But don't go nearby that.
That is why I'm for 50 days.
Yes. So don't go, one of the condition is that don't go nearby that. What is that called? No, Thakurbari. Don't go near Thakurbari. That is one of the conditions.
Item 17.
Yes.
14 one they will custody.
For first tell us the allegation, then come to the custody.
Yes, madam.
Don't think that unless we will on custody will allow you. Let us see what is your involvement.
120 40.
Space.
FIR case number 12, madam.
12.
some kind of SIM card and GPay ID recovered.
Serious offense, so
That is recovered from from other places, not from my banking source. They play development. And we are in company for 41 days.
A case that will be required. How many days?
41 days. ma'am.
Both of us bring, let us see, because it's so serious. How these are used, 802 SIMs, 239 of GPay UPI ID scanner.
I have already.
Be there for some days, enjoy the hospital.
Also, there is no 29. ma'am.
Mr. Bothakur will decide. That part is,
It's for my daughter.
8 of September.
8 of September. You convince Bothakur,
Yeah.
and on that date you convince Bothakur.
29. ma'am.
Ask him.
29. ma'am.
Ask him. If moment he agrees, I will say,
No, already you are also there with many other cases.
okay, she is also saying not possible. 20. First of September. At least he is successful people in that way.
I'm not saying after September,
8 9.
Very long, ma'am. 41 days is
Be there. So many SIM cards, so many GPays. We do not know how it is. It's not a simple case that you have entered into somebody's. Eight. Don't waste time. Yes, next case.
Item 18,
Yes. Yes, Mahajan.
participated in that procedure, ma'am, in before the- and primaries are.
Oh, that processor.
90% is able to decide.
That Mongoldo.
only one mobile.
Yeah, but all those organizers even got anticipated. Why should they be inside? To the to the satisfaction of
Ma'am, CBM Mongoldoy.
CGM Mongoldo.
Mongoldoy Dorong. Highly of them.
18,
1800. No, this is 19.
19,
This is 19.
19.
I think Mr. Mahajan, your case was 18. This is 19. Yes. Mhm.
The name of the particular is that it has discharged his license. The payment has been paid once not paid. That has just done everything. And so regarding to ascertain that fact also,
Many cases, not single case.
every case of
Not every, same allegation. Same allegation. You are not the only counsel. And this is not the first time that we have dealt with this case. Twice I have rejected. And in interim order, I granted on the condition, on the request that I will repay. And CD specifically says that he is not cooperating in other cases.
Yes, yes, so statement about it, denies the allegation, verify the.
Then why don't you arrest him? In other cases, you say that he is not cooperating. What is the nexus between you and him? Tell us. We have rejected in 2 cases. Sima Pegu already murdered. We do not know to whom, according to you, have paid money. She has already been murdered. Now investigation is going in a different direction. Rejected. CD returns.
My submission may be recorded.
Yes, yes.
That much logic.
Yes, yes, we'll record.
Yes.
I must submit that the where have you have made some statement, which order?
I've created all statement, I have given the money receipt, I have
Okay,
given the
okay.
bank statement.
It is the case of the petitioner that the amount which is stated to have been cheated from the informant was the Sima Pegu, is not it?
No logic, no. That is already been done.
Okay, money has been returned back to one Srimati Sima Pegu amounting to rupees 35 lakhs, and she has also issued receipt. Full stop. From the material available on record in the case diary, the IO has specifically mentioned that in the meantime, Sheikh Sima Pegu has been murdered, and the police is investigating the matter in a different way. Therefore, at this stage, the petitioner should not be enlarged on bail. Full stop. Considering the matter in entirety, including the specific allegation against the present petitioner, this court thinks that this is not a fit case for grant of privilege of anticipatory bail. Accordingly, the present applications and dismissed, interim order pass and stands vacated.
Give them.
Item 20.
In this case, statement of the this person Nivani was there was a second report not yet received.
What is he?
He is by the assistant professor of biochemistry.
So,
Allegation is
can that be a ground to be treat you as a non-criminal?
allegation is that while
Force the thing as handing over charges force itself.
and now the original handing over charge is come to the second floor of that report.
Are you an interim? Okay, Bhattacharya submits that the signature, the alleged forced signature and the search report has been sent to the FSL for forensic examination, forensic laboratory for forensic examination, and the investigating officer is awaiting for such report. In that view of the matter, while extending the earlier interim order, it is provided that by the next date fixed, the CD be produced along with the FSL report. Place this matter on
29th of
29th.
Item 21.
Yes. What updated CD? Tell us, where is your FIR? Okay. Oh. Hmm.
Then the complement of updated circulated the advertisement.
Hmm.
After going to informant contacted, then we asked the informant to contact the phone number to put in the advertisement.
Hmm.
Thereafter, the informant contacted
YouTube link.
the phone number.
Hmm.
Their number 2.
Then what happened?
Then my God, both of them
contacted each other minor and it is very clear the number two collected the document only from their passport and secretary month.
But under what authority you publish advertisement that provident fund can be withdrawn like this?
Otherwise, he was not involved. He is the main person. Otherwise, in his YouTube channel, that advertisement was published.
Publish.
One phone number reflected the informant might have contacted in that phone number. Thereafter, provided all his Aadhaar card, PAN card. By using the Aadhaar card, PAN card, they open their bank account in the Bandhan Bank. Thereafter, Mr. Kotik took that amount.
The provident fund was transferred to that account, new created account.
And now, he is already in his statement, the present person stated, he has already deleted that video from his website. And my lord, he deleted video, he is also trying to conceal the evidence of the intention. It is the manner noted here. My lord, he even does not know that person, my lord. Only.
You may not know, but you are a YouTuber, you must know. Suppose somebody says, upload this pornographic scene. Will you upload?
No, my lord.
Will you upload?
No, my lord.
Then somebody says, you upload this, will pay you money. You must verify that what effect it can have. And in that you give a link that contact this person, provident funds can be withdrawn. Provident funds can be withdrawn by the person. So you must be a part of the conspiracy.
You are not aware, my lord. And my lord, here also stated in his statement that phone number which is provided in his YouTube channel, it is the one Abdul Haq. And whether the existence of that Abdul Haq is there or not, that police has not yet arrested that.
Okay. So still investigation is required. Considering the material available on record in the CD against the petitioner, as well as a stage of the investigation, this court is of the view that the petitioner is not entitled for the privilege of pre-arrest bail. Come later on, we'll see privilege of anticipatory bail. So accordingly, the same stands dismissed. And these are most of the victims are the retired and helpless persons of this kind of thing. Yes, rejected. Interim orders, if any, stands vacated. 20? Yes. Will not say 2 p.m. Suppose we are free, you do it. 2 we cannot assure. Suppose before 2 we finish the list, what will you do? As a last item. As a last item. Yes, next.
23.
Why? Series there, what about? Huh?
23 minutes is
Is there enough to see? Okay, when?
here in this case, whether this case registered or not, the pending evidence is not.
And then, okay, the report as called for by this court under its order dated 28/4/2023 is not received. Mr. Bothakor, it's from April 23. We are in September almost. People,
The report as called for by this
court under its order dated 28/4/2023 is not received. Full stop. Accordingly, Mr. Bothakor press for an is granted for listing the same on 31/8/2023. Full stop. The IO shall produce the report as directed without fail on the said date. Interim order pass earlier shall continue.
24.
23 is over.
Yes, then we not received the
Okay, when?
and 10th of October.
10th of October for interim to continue.
25,
None appears to city received. None appears for the petitioner on call. The case diary as called for is released. Is received. Also, received. What is the where is the affair?
This case is still, I have a new case there as well. I have come to the petition,
None appears for the petitioner on call. The
delegation is that one petitioner is the husband of the
just a minute. The Honorable Apex Court in the case of Taj Muhammad versus State of Uttar Pradesh and other arising out of SLP criminal number 5298/2023. While relying on the earlier decision of the Honorable Apex Court in Madanlal Kapoor versus Rajiv Thapar, reported in 2007 7 SCC 623, and Bani Singh versus State of UP, reported in 1996 4 SCC 720, under its order dated 11th of August 2023, provided that even in absence of a party or his counsel, revision petition calls for consideration can be considered on merit in accordance with the parameters for consideration of a revision petition. In the considered opinion of this court, such principle can also be applied in case of bail application when the case diary is produced. Full stop. In that view of the matter, though the learned counsel for petitioner is not present, this court has proceeded with this matter and perused the case diary. Case diary is it. From the perusal of the material available on record, and also validation, his conduct of cooperating with the so-and-so, the present application is allowed by making the earlier interim order absolute. Yes.
26,
Now, Mr. Das will not appoint any amicus. Yes. Where is the affair? Complaint case. Then it was registered as an affair. Case 15. He recorded his statement. Who is your senior? Oh, yes, tell us. Hmm. You are Bhavesh Mishra, he has purchased the vehicle in how? How have you purchased the vehicle?
I purchased the vehicle.
Hmm.
And in the year 2022 July.
Hmm.
From July onward,
Hmm.
I deposited the EMI. And the car is not in running condition. I need to start, Rashid from the case.
He now won this vehicle, he has not paid the EMI, I'll let him go. You are Mr. Vijay Bhavesh Mishra,
My lord,
but why are you not appearing? That is the difficulty.
I appeared first. On 4th of July, I appeared first.
How do you know anything to show?
I have had additional evidence.
Yes, madam. He has specifically stated that he has appeared. Why this I am getting in many cases, petitioners are saying we appear, but our statements are not recorded. We went there for 3 days, statements are not recorded, and police gives a report that he has not been. Should we give an inquiry against that investigating officer by another superior authority? Have the instruction. Have the instruction whether a further investigation is directed against this IO. Because he has made a specific statement that he appeared on 4th of July, his statement was recorded. Statement was recorded. You have the instructor, we are taking after some time. And intimate your investigating officers. If these two types of stands are taken by petitioner and the IO, we will ask for specific inquiry. And Mr. Das, what about this implementation of Supreme Court order that every police station must have a CCTV? Every police station must have a CCTV. All these accused interrogation and all should be under CCTV. But there is a PIL. This is a mandate. Fan cannot be. It's a mandamus by Supreme Court. Yes, madam, have that, and we'll ask whether in that station whether there is any CCTV. That they have started. They have started. We know that because while sitting in a. Why I'm saying is in many cases I have seen this. They will make a statement that we went on such and such date, then such and such date. He said, I am busy, and subsequently he gives in the report that he has not appeared. Maybe for reasons other than bona fide, and then we'll ask for special investigation. You have the instruction and send a message if I am here sitting in this bench. Yes, time being.
27.
Yes. Yes. Yes.
Relegation is that some unknown person that has stolen eventually to pay Airtel down.
Oh, that case. No, that was something different. Highway. Where are you apprehending?
You understand, one of my worker, he was arrested in different case in the 70 case number 30/2023. Here in this case, he was shown arrested by the Domoga police. And now the Domoga police has asked me to appear for them. I'm ready to cooperate with them, but the watching again is protection. Because I do not have any idea whether Nadir Ahmed, Nadir Uddin, I have specifically mentioned the carrying of 3 of them.
You said last, this is also a case repeatedly happening. These cab dealers are arrested or they are coming for anticipatory. In one case, what happened is a vehicle was stolen. It was in a bad condition. It was cut into pieces by 4 or 5 laborers. The laborers were called by the thief that cut it down. They cut it down. Then it was sold to a scrap dealer. He thought it is a scrap. Now what to do? What is his role? Scrap dealer. He has stolen. According to whom? So if you have done this, how can you grant you anticipatory bail?
For my instruction.
Anticipatory bails are granted in certain special circumstances.
Check in the paragraph 3, I have categorically stated no. That's why I am defending arrest. This code is used.
What is your name? This-
Elias Lombo.
Sarifuddin alias Lambu. And Joinul is the person according to whom who was the main culprit, according to him.
But
Okay.
in my petition, I have nowhere said I am Elias. I am only sorry. I have nowhere said that I am wrong.
May not be, but your employee will know that you are Sarifuddin alias Lambu.
After coming out from there, keeps telling me of implicating in a false case, and that is why that statement was made. And that I have categorically stated in paragraph 3 of my.
Who is this Fakhrul Hussain?
petition, I do not know that. 79 days worship, the punishment is 7 years. There are specific guidelines that 41 is required to be mandatory.
Okay, we are giving you, go there.
Yes, Lordship may direct him.
We will not give you interview. Give a 41 notice, that is his grievance.
That observation.
You give a 41 notice, let him go, and whatever you want to do, you do. You are not.
Registry has also issued.
34 better is. Rejected. However, they rejected. However, if the investigating officer requires the interrogation of the petitioner, the notice under 41 A 1A or it was 41 only 41 41 notice and the guideline laid down in Honest Kumar be followed. Rejected.
28.
Specific allegations are made against him, and then it is also found that he was involved in earlier offenses. Earlier offenses. She did not receive. Maybe. Okay, when? 11th of September.
29.
Yes, Mr. Doctor. Okay.
Now, FIR has been logged because there is number of cows are missing, 850. Now, that in my case, it was 195 cows were received, and 170 of them died in natural death. Postmortem reports are in all of them next. So these are the cases of this, they already come in bad shape.
Is there any requirement of further investigation whether these postmortem reports are correct? You are a Goraksha. Goraksha.
They come in bad shape, madam.
Was a part of this group, was operating Goshala, which was not even permitted by the DC office, has been only. And also.
But Gosala running without permission will not be a criminal offense. You may shut down his Gosala.
I have been it's the one who is-
Huh?
I believe it's the one who is- And I was also allowed to keep my. That was like.
Any interim?
Statement is not recorded.
Okay, why? Go and get a statement recorded first.
He appeared.
When?
That's not the council position. You have to give a- that's not legal matter.
Give a date so that we can tell the IO that on, according to him, on such that he appeared. You have it. Then we'll send, return back the CD since you are interim and get your statement recorded. Okay, now we are detailed. It is submitted by the learned counsel, learned additional public prosecutor that after the interim order was granted, the petitioner has not appeared and got his statement recorded. However, such submission has been countered by the learned counsel for the petitioner and submits that on,
So it's a-
he will definitely keep it switched off because he has not gone. Has went to the police station and got his statement recorded. As the dispute has been arised, the CD we call for and petitioner shall appear before the IO on. Can you send it the CD today on Monday? Huh? Manka sir. So on give a date next week, last part, Friday. Huh? 8th of September, 11th of, no, he record his statement on 8th of September, 8th of September. And thereafter file an affidavit that he went to the police station and got his statement recorded. If the petitioner appears, the IO shall invariably record his statement and return back the CD on 11th of September 2023. Interim order passed earlier shall continue.
Item 30,
Yes,
You know, already applied and recorded.
what is the offense 420? What kind of 420 you are?
Already arrested.
Who?
Aminul
Aminul Haq. Then
and,
when arrested? When arrested? Give me the date.
10 is 2020.
10?
8,
How can? 31/7 we have protected him. How can he be arrested? Then we have granted him interim on 31/7.
Since you granted to 2 and 3. No.
3 shall be allowed to go on, namely Aminul Haq, Imdadul Islam, and Joinal Abidin shall be allowed to go on pre-arrest bail on furnishing of bail up to 20,000. This is an illegal detention. Have instruction. Yes, of course. This is if this is done, this is serious.
31,
Receive. Yes.
Same as 27. That's why you were. He is approved. You will also found the name of Fakrul in that case.
Okay, that Fakhrul. He is one of the main.
All are there.
One of the main Fakhrul. Not only 34, many others. Your target is Airtel Towers.
Fakrul, Rambo,
And
Bhatia,
the other person, he was given only 500 rupees to carry the weight from the tower to the vehicle. See, he was first arrested and you are anticipated. Rejected.
32,
Yeah, I got it. Rejected. FPR 41 notice only. Yes.
Hello.
Hmm.
Sometime be given to me, but I have not.
After
item 53 of supplementary list.
if an appears for the petitioner on call, is the recall for is not received. Accordingly, matter be listed on. 14th of September. What is this? Till then, interim order pass out.
So orders, item 33,
Mothakur, in that case, 390 or not 300, no, that 300, that additional evidence. I've gone through it and also gone through different judgments. At this stage, that may not be possible in absence of an application. So what we have done is we are supposed to make a mention for to be spoken. Since you are here, Mr. Das or Bothakur was there. Bothakur was there. No, not this case. That earlier case where he wanted the DNA test. I have made some research that may not be possible at this stage. You will have to file an application which can be considered at the final hearing stage. I have gone through. So therefore, though we thought of giving you a chance to you sending it for a DNA test cross-examination, we have not passed that further. What we have done is, considering the matter, we have granted you bail. We have granted him bail, taking note of the contradictory statement of this. In the meantime, it's better for you to file an application. We'll hear the matter and decide it. What happened is I specifically took a claim. Mr. Bothakur was there. The lady says that I had an affair with him. He did not marry her. So she had a grudge against him. Specific evidence. And her story is that on that day, this person came near their house to wash his bike. I think they are next door neighbors or something like that. He in the meantime got married to other girl. So he asked for some betel nut. They went inside the room. Then he raped her. And she said he promised her on that day also to marry. So therefore, she gave the consent. Now, affair was lost after 7 months when pregnancy could not be terminated. There was a village man, refused. Then he denied the thing at all stages, including his 313 statement that no, this is not the case. I am having a baby of 5 months. This is absolutely false. This is his statement. Now he took a stand during investigation, not trial. I have gone through this. During investigation, file an application before magistrate that let there be a DNA test to verify who fathered this children, because her case is that he is the father and that is the result. So I was initially thinking that we will pass an order still to do the DNA and all. But ultimately, after doing some research, I thought that this is not the stage. So we have granted him a bail, considering all this. And it's up to him now to file an application, then we'll consider it. So we'll not list it for to be spoken, we'll upload the order. Okay?
In fact, I have found one document where it says that after being married.
Yes, that's the same thing. So okay, that's why I kept it that I did not dictate in the court. What is this? This is the matter to be spoken. Okay, we have already passed the order. Oh, this is the matter. Okay, I thought. Okay. This order has already been dictated, uploaded. I stands disposed.
item 34,
Yes. Mm. We'll go to that later on. In view of office note dated 31/7/2023, the Learned Counsel for Petitioner submits that due to inadvertent and mistake, steps were not taken. However, we will do the needful within a period of 5 days from today. Prayer is allowed.
23 Lordship and then
3, this is the order of 3-8,
23
0308.
possible to have that mistake Lordship on that.
When?
23 Lordship.
Okay, notice has been issued only on 9-8. So we'll have to wait for some time. Okay. What is the offense?
My picture and my manipulation and my picture is not matching in this file.
In
My picture, I was appearing in the exhibition after my picture and confirmation of this is taken in online. And I was a physical picture appeared. And there my looking at my picture and my confirmation was not matching in biometrics.
definitely. So you have made a forgery.
No, Lordship. No, Lordship. And earlier was everything is done.
Now where is the you want to cause what? Where is the FIR? 17. See, nowadays you will have to upload your thumb impression and photos to scanning. And they have their own machine to match it. FIR space. Manikali. So
And one is, yeah. Also, not sure that that is what we have done. And same purpose, but further in the block arise with that. And because then he was challenging.
how do you decide that? How do you decide that under 480 to tell us? That this is wrong, then we'll have to bring a box here. Then your person will come, forensic expert will come. This is not a job in 482.
And
There is a specific allegation, impersonation. Method ends there. Then they will investigate. If you are correct, then they will give final report. If you are not correct, they will file charge sheet.
And same post is also lying working and not final. This case is
So tell me, can there be ground for causing a criminal proceeding under 482? If you can show anything that because he is having his future is at stake, a person who impersonates and appears in exam can an FIR loss can be caused under in exercise of power under 482. No. Can we decide this? Any cases made out on the basis of the FIR. So what remains?
And what can come, case number 72 and related person comes from case number 72, the order files will be landed court to do nothing.
Yes.
There is some observation is made out of it. And Arnash Kumar versus here in this case, and there are some procedural laid out of it. And that is not worked by the hour, but I am illegally detained.
So now file an application, illegal detention. Can there be a ground for quashing the FIR?
For a moment, case number 72.
Yes.
And then legal person.
Your next ground is that while arresting you, Arnish Kumar was not followed. Can that be a ground for causing an FIR?
No.
Then where you are arguing it?
Some observation that because without any.
Can that observation in bail be a ground for causing the FIR? When a cognizable offense is made out.
Yes, this can start to be.
Ah.
And for I can be police
do a defense case.
My lord, initially already computer-based test examination was already held. Probably on his behalf, maybe someone other may appear, and thereafter when physically secretary, he appears before the. My lord,
He thought that now what happens is not only this examination. I had this experience on my own while my son appeared some in All India exam. You will have to your signature, handwriting for the purpose of handwriting, thumb impression and photograph, recent photograph. You will have to upload, and there are some specification with this and that. Not anything will the computer will not accept if you upload that if your fingers are not clear.
No.
So then they can match it with their machine. So they say that it did not match. So impersonation. We cannot comment on marrying. You may be right, absolutely. You cross-examine, confront with him, them with your record. You file, give defense witness, but can that be a ground for quashing an affair? Can we decide all this in 482? They may file a final report against you. They may file a search sheet if you might get a chance for to argue for discharge. If investigation is faulty, you will be acquitted. But can that be a ground for exercising power under 482 to quash an FIR when prima facie reading of the FIR cases are made out?
Take more time because there are lots of cases like waiting the police for investigation. If that is why was for this honorable court and they have to immediately submit the report. Whether I'm the person or not.
Now tell us, what is your argument? Your prayer is to quash this FIR. Please tell us what are your arguments.
There is no case for that.
What report?
My earlier picture and on that.
So you want that we should monitor the investigation? If they don't have their proof, that will go. If they cannot prove, they will give a final report. What report we will call for?
Regarding investigation what is there.
No, this is not a case for polling records.
Investigation then if there is something not here, everything will come. It's better for him to go back to the investigation.
If producer, yes, but how there was an order for case diary.
If there is also one more time.
There's no case. This case there is a call we do not know anyway. Where is the order for case diary?
Not received. Then otherwise, this is not for filling up of 24,869 posts of my constable.
There is no direction for case diary.
From the contents of the account.
Art. Learned counsel for the petitioners. The present application is filed for quashing of an FIR dated FIR dated. Where is the FIR? FIR dated 6/5/2023, which reads as follows. Full stop. It said follows page 70. The learned counsel, while urging for quashing the FIR, argues the following. Yes, first argument. Tell us, argue.
My simple argument, Lordship, that the investigation is going on. And if I have the person, Lordship, that people will become that because my earlier picture.
It is submitted that the investigation is going on, and therefore investigation is going on, and the petitioner has not committed the offense, and therefore
And therefore.
And therefore?
Earlier biometric and on that page I have my biometric and my picture is matching. And if there is not matching, that is the count. That if there is no case, and if.
Submit
This is going on and the petitioner has not committed any offense.
any offense and committed any offense, and investigation will reveal that he has not used any biometrics earlier, wrong biometrics, and he has not impersonated and photographs. Full stop. Whether the petitioner has actually committed the offense as alleged is the subject matter of investigation, as the learned counsel has rightly submitted. However, law is by now well settled that a power under 482, section 482 CRPC can be exercised by this court on the following circumstances. In the present case in hand, reading the affair as a whole, it cannot be said that no case is made out. Therefore, in view of the settled proposition of law, this court cannot exercise its jurisdiction under 480 to quash an affair. At the same time, the argument advanced by the learned counsel is a subject matter of investigation. If the facts narrated by the petitioner is correct, and the investigation is concluded in that line, invariably the investigating officer will have to file a closure report. Therefore, at this stage, this court, on the disputed fact that the petitioner has not impersonate himself, cannot be a ground for quashing an FIR. Full stop. Accordingly, the present criminal petition stands dismissed. Hey, on the basis of this law, these are the following propositions. Yes, next.
35.
Yes. In preferring what? Against conviction or acquittal? No, the judgment is for conviction or acquittal. Period. 10 years. 10 months. 10 months. What happened? Condone the delay. Heard Mr. So-and-so, learned counsel, and also heard Mr. Bhattapur. Which paragraph have you described the delay? Paragraph? 2, 3, 4, and 4. Accordingly, delay condone the registry to register the connected criminal revision petition, and list is in the motion column. Next week.
For enforcement of orders.
Higher disposal. Bail hearings, you get a leftover. No, now we are calling the leftover bail matters now.
Item 26.
Yes.
26.
That is just now we have taken up this. Yes, Mr. Das, Pamesh Mishra, that vehicle.
What happened?
See, these for this we do not require her interrogation, in custodial interrogation. What happened is the vehicle was there. The owner says, my mother fell ill, I went somewhere else. Might be he failed to pay the EMI, the informant. He went to his native place saying that my mother was ill, I went there. And subsequently gave his Jimma to somebody else. And that vehicle was sold to this person, you. And he has purchased it. So what? Purchased it, it might be by the This HDFC also, finance, who was the financer? Tata, who is the HDFC? HDFC member.
Showing money received for online to the complainant center. Transfer money. Now, because of the complaint case, we must have received the summons to this complaint case and we has come up with this FIR in between my and we filed the complaint in February. And police has our complaint, money, received everything, the online transactions, everything.
Have you any interim protection in your favor? Have you appeared?
I appeared, my lord, what happened? The accused, he appeared along with his lawyer, my lord. And the, for the preliminary talk was there, he said, "Na gadi lo yaha can take it." And because we have to hand over the vehicle and the documents to the registered owner, thereafter whatever will happen. Then the council said, "At least you keep the surveillance copy because I'll have to tell the court that I was not here." And my surveillance copy was kept. We also submitted a copy of the complaint that we already filed complaint to the not malicious FIR done. In this case, and then after that, we did not go matter because I.
Where yes.
Also, I have talked to the also, he stated that the accused have not appeared. His advocate appeared on behalf of the accused.
So we are saying we are extending the interim order. Get your statement recorded. We are giving a date. Give a date.
We can put only one license and that is not ask for the vehicle to be and any document that I have to be handed over. That I not because of my complaint is my whole case is so many.
No, vehicle is in whose possession?
I spend more than 5.
Can we say that don't seize the vehicle? That is the problem.
That's done online to the complainant file. In these circumstances, I have every time of the case. Otherwise, and I have a complaint
Where is your receipt?
the money is copy of the even installment also by 321 to 330 all these my love. Not page 21, from page 18.
You'll record your statement, give all documents. Yes, Mr. Das, what is the meaning of seizing the vehicle for the time being? Everything is there on record. It is nothing but an harassment. You appear here, get your statement, give your all the documents, whatever you have, and no vehicle for the time being. Okay. The case of the petitioner is that the petitioner has duly purchased the vehicle, alleged to have a vehicle from its owner, registered owner, and in support of such document, in support of such contention, certain documents and money receipt has also been annexed with the present petition. Money receipts are also annexed along with this document. The fact also remains that, what is your name? The fact also remains that the petitioner on an earlier point of time, that is on 23/2/2023, filed a complaint case being complaint case number 72C/2023, arraigned the present informant, is not it, as accused in this case, with a allegation that, what is your allegation?
That we did not sign the sale letter and
Alleging the commission of offense under section 120B and 420 IPC, in as much as it is the allegation of the petitioner that the informant, even after receiving the money, has not transferred the vehicle. Not transferred the vehicle. Full stop. In view of the aforesaid backdrop, and full stop. The FIR was lost subsequent to filing of the complaint on
On 6/6/2020.
6/6/2023. Full stop. The petitioner contends that pursuant to the interim order passed by this court, the petitioner, though appeared before the IO, however, the IO is insisting to produce the truck, and the petitioner apprehends that the trucks for which she has paid money and filed a complaint may be taken custody of by the police, which will affect his livelihood. Full stop. Be that as it may, in view of such disputed facts and lodging of complaint by the petitioner and the subsequent FIR by the informant, this court is of the view that the petitioner petitioner should present himself before the IO on give a date, on which specific date? Not tomorrow, on Monday. Appear before the IO on that give a date. 28/8/2023, along with a copy of this order. On such appearance, the IO shall record her statement, his statement. Since you are hard, that's why his statement. However, at this stage, it is provided that the IO shall not insist on the production of the vehicle, subject to further order in this case and after perusal of the case then. The interim order passed earlier.
Item 30, pending matter.
No. Yes, wrong, but the same order, I will furnish to the IO. Because passed on
31/7.
Hello?
31/7/23.
no, 1/8/20. And that order was passed in AB number 2635. Where petitioners number 2 and 3 were granted administrative.
So there are two bail applications.
Maybe, I'm not sure, because I have to find out this petition. Perhaps in this petition, interim order is also.
AB 2635. No, two cases are different.
Hello?
This is Goalpara PS case 107 of 2023. This is Nagorbela police station case number 78 of 23.
The case there is November.
This bail application is passed in Nagorbela police station case number 78 of 2023, registered under section 366, 294, 34. And in this case, Goalpara PS case number 107/23 under section 420, 506, 34. Sections are also different. And here it's Aminul Mondal. Here it's Aminul Haq. Here it is Aminul Haq in case before me.
Yes, this is Aminul Mondal.
And this is Aminul Mondal. And offenses are two different offenses. Different police stations. Case diary of what?
Case there of 78.
Nagorbela.
November.
Wrongly case diary.
This one.
Case diary should be of Goalpara PS case. Goalpara PS case number 107 of 23 under section 420, 506, 34. Isn't it?
I'm not sure.
This is AB 2609. Mr. Das, this is AB 2609 of 23.
Yes.
And the case diary came in 2635 of 2023. There is a difference, the 9 and 5. Okay, it is submitted by the learned additional public prosecutor that wrong case diary has been sent accordingly. Matter may be adjourned to get the CD in connection with Gwalpara PS case number 1011/2023 registered under section 420/506/34 IPC. Full stop. Prayer is allowed. Accordingly, list this matter on. Interim is there.
It is September 29.
September 29. In the meantime, the interim order passed earlier shall continue. The case diary in connection with Nagarbera PS case number 78 of 2023 is returned back. Last.
Washman, item number 36.
Complaint and order. What is the complaint? Page 39.
Yes.
Huh? What is 39?
So, the original and then
Page 20. Who is representing the other side? Kothari, P data, P. Musumi, go on, call the admissions first. Maybe it happened yesterday also. Many people have not come because we straight away called the question. We'll start it from admission. That happened yesterday also. Because this is the new head we have created. Yes.
36.
Here, this case was taken up by someone else, but it is possible to kind of file now.
It was taken up by someone else judge or someone else lawyer. Who was that someone else? Jian Sahala also. But madam, this is a 2019 matter. You are enjoying a stay. When? Who is your senior? P data. Who is P data? PK data. I mean. Where is he? Wait for some time. It's a commercial something or negotiable instrument.
Is also covered by another base of the apex. If I have the issuance of the check, check was issued on 37. I have resigned from the company on 37. And that has been also accepted by the company that reflected in the website of the.
That ROC.
There, I mean, when you complain, there's absolutely no allegation.
Okay, I think there is some judgment on this.
Yes.
We can close it today. We can, yes.
You might need some time.
Files is not with you. Different problems. How many problems will you handle to do a case? You are, madam? NT Mapung, Learned Council submits that her senior, Mr. P. Decca P. Decca has recently been engaged in this case and accordingly seeks some time to argue the case. So how will you collect these documents? Get it xerox from him, don't give. Get it xerox. Accordingly, matter stands adjourned and be listed on 7th. No 7th. If he's enjoying the stay, get a little longer day. If they are not interested, he's enjoying his stay. 26th of September 2023. Interim order pass earlier shall continue until further orders.
37.
Yes. Huh? Why? Okay, what is the matter? So you don't come here. We have a handle yesterday. Judgment has been passed by the Honorable Apex Court. In absence of petitioner or its counsel, we can decide on the settled proposition of law and merit in case of, more particularly in case of revision. We no more require any lawyer. We'll go on merit. We have our all books is fitted inside. All judgments are there. We'll decide on our own. Why we need J.C. Gogol? Oh, you will take an adjournment and we'll fix the date as per your convenience. September 2020. Any interim order stands vacated. Interim order to continue. Yes. Yes. Where is their affidavit? Whatever. Story is something different. But how can it cost 376? Yes, what is your step?
Now I have no.
Your husband was not there on that day. He is your brother-in-law. And you lost the affair after how many days? 31,
31, 20. After,
31, 20.
After 6 days. After
What is your stand?
No, if no objection is I will go to this question.
You did
Now-
not, you did not have objection on that day also, but somebody might be eyewitness. We cannot, we'll have to dismiss your petition. Go face the trial, give evidence. Yes. Mm. Lakshmi Narayan. And then,
But subsequently, that discussion of the opposition completely, that serious analysis getting order, providing this type of questions normally occur.
not normally.
Yes,
It cannot be,
yes, cannot be.
not normally.
Yes.
The word in Lakshmi Narayan is it cannot be.
Cannot be.
So this is a case 376. So we cannot.
True, true.
If true, we are dismissing a
That
petition.
is what I'm taking submission.
Yes.
Subsequent to that decision.
Mm.
Again, the Supreme Court is taking some legal view
Mm.
and taking some other views in recently matter.
Mm.
And those judgment are
These are given a given facts in exercise of power under 142 when the rape victim married the other person, isn't it?
that is a difference.
Yes, sure.
Here, this is a very, the only question in this case about. But this is a decision of 2023. It's very, here the only question is that whether. But the very first, there are two words. The appeal challenges judgment and order details so and so. First, that is under signature of the High Court of Delhi. They are the dismissing the criminal MC number so and so of 5. The application filed with the respondent for quashing the duty under civil 360 of India Penal Code come to be. A signature of the Honorable Delhi High Court manner rejected the petition for quashing the position under that Supreme Court manner. Parliament relied on the previous decision of the Supreme Court that was given in normal procedure. In normal procedure, in that case, in normal procedure, on 3 was what? That is also here, relying on the observation of the normal procedure, there are 13, 14, 15, 16,
Where is Lakshmi Narayan? Lakshmi Narayan, are you having? And thereafter Jagjit Singh or something like that.
That is family matter. One normal changes is very relevant because in this case, new guidelines have been getting the
Yes.
this judgment will take.
Narendra Singh.
Non-machine. It's a 14 this one. Here, new guidelines have been getting for quashing.
Where is our class?
Like the heinous offenses, like the categories of offenses, those who were not earlier what about. Now, they are not taking some new guidelines.
Lakshmi Narayan citation to this. Lakshmi Narayan to Amar Islam. Amar says, yes, which paragraph?
There are 28, 29, 30, 31. Here, the amount the stages of the proceeding. The stages.
Paragraph?
There are 28 and 30, 31 condensing at that. And 28,
Okay,
29.
let us see the guideline.
Fine. In view of the offset, there are 31. In middle portion of the segment, there are 31.
In view of the official discussion with some of and later on the following principle by the High Court would be guided in giving adequate treatment to the settlement within the parties and exercising its power under the authority of the court while accepting the settlement and watching the proceeding or refusing to accept the settlement with direction to continue to the criminal proceeding. Our purpose under the authority of the court is to be simply inform the power which lies in the court to perform the offences under the 320 of the court. No doubt, the authority of the court, the High Court has inherent power to trust the criminal proceeding. Even in those cases, we shall not compound when the parties have settled the matter between themselves. However, this power is to be exercised strictly as the number 2 clause. When the parties have reached the settlement and on that basis, petition for quashing the criminal proceedings filed, the guiding factor in such cases would be to secure the ends of justice or to prevent abuse of the process of any court. While accessing the power, the High Court is to form an opinion on either of the opposite two of the particular ends of justice and to prevent the abuse of the process of court. Then the second judgment, particularly the 6 and 7, these two judgments are very important for this.
Which paragraph?
The bottom clause 6 and 7, these are the main judgments. Offences under section 307 Indian Penal Code would fall in the category of heinous offense, heinous and serious offences, and therefore is to be generally treated as a crime against the society and not against the individual. However, the High Court could not raise this decision merely because there is a mention of section 307 Indian Penal Code in the FIR or the charge is termed under this provision. It would be open to the High Court to examine as to whether the information of section 307 Indian Penal Code is there for the sake of it or the prosecution has collected sufficient evidence, which, if proved, would lead to proving the charge under section 307 Indian Penal Code. For this purpose, it would be open to the High Court to go by the lesser of injury such as whether such injury is inflicted on the vital or physical of the body, lesser of the body,
2012 NSCC লাগে আর 2019 5 SCC 680 বিহারে এটা তিনটাই লাগে 2019 6 SCC. Yes.
On the basis of this analysis, the High Court can examine as to whether there is some possibility of
Which paragraph you are reading? This judgment, na? State Kapila Gupta. Okay. This you are reading.
There are 31, but in the next page, there are some clauses. There are 31, clause 1, clause 2. Now I'm reading clause 6 and 7. These are the very adult guidelines.
You have read clause
6,
earlier you read clause 5.
So earlier I did clause 1, 2, 1. Now 6.
Yes.
Offences of the system created some Indian penal code would fall in the category of heinous and serious offences and therefore is to be generally treated as crime against the society and not against the individual. However, the High Court did not raise its petition merely because there is a mention of section 307 Indian penal code in the FIR or the such is framed under this provision. It would be open to the High Court to examine as to whether information of section 307 Indian penal code is there for the sake of it or the prosecution has collected sufficient evidence, which if proved would lead to proving the charge under section 307 Indian penal code. For this purpose, it would be open to the High Court to go by the lesser of injury sustained whether such injury is inflicted on the vital parts of the body.
The charge sheet has been filed.
Yes.
Sir.
That's it.
Okay.
Medical report industry of injuries suffered by victims can be generally deemed the guiding factor. On the basis of this probability analysis, the High Court can examine as to whether there is a strong possibility of conviction. All the chances of conviction are remote and clear. But these two are the main factors. In the former case, it can reduce to accept the settlement and for the criminal proceeding, whereas in the latter case, it would be permissible for the High Court to accept the plea, compounding the offence based on complete settlement between the parties. At this stage, the court can also be assured by the fact that the settlement between the parties is going to result in harmony between them, which may improve their future. So ultimately, my lord, if there is a very delicate of condition, in that case, would be broken, even exercise the power under the for the proceeding. Otherwise, my lord, even continuing a criminal proceeding, ultimately it will be process of a criminal court, my lord. Instead of that, the court can take up another important issue and give justice to someone else in place of the party who are taking. This is the ultimate objective of the. Now, clause 7 also will make some. These are very important. Clause 7. While deciding whether to exercise its power under the authority of the court or not, timing of settlement play a crucial role. But timing is of the status of the proceeding is of very important. Those cases where the settlement is arrived and immediately after the alleged offence of alleged commission of offence and the matter is still under investigation, High Court may be liberally in accepting the settlement to avoid the criminal proceeding investigation. It is because of the reason that at this stage the investigation is still on and even the success has not been filed. Likewise, those cases where the charge is framed but the evidence is yet to stand or the evidence is still favorably, or after private assessment of the circumstances material mentioned above. Even in a case where the charge has been framed, but prima facie the material in the case are covering the or covering or coming is or covering the take a liberty. Likewise, those cases where the charge is framed but the evidence is yet to stand, or the evidence is still at infancy stage, the High Court can show benevolence in exercising its power favorably. But after prior assessment of the circumstances material mentioned above, on the other hand, when the prosecution evidence is almost complete, or after the completion of evidence, the matter is still at the stage of argument. Normally, the High Court should refrain from exercising its power under the authority of the court. As is such cases, the trial court would be in a position to decide the case finally on merit as to come to a conclusion as to whether the offence under the given exempt to be proceeded or not. Similarly, in those cases where the permission is already recorded by the trial court and the matter is at the appearance stage before the High Court, where compromise within the parties could not be a ground to accept the same resulting in acquittal of the offender, which has already been executed by the trial. Here, the charge is proved under the 3 books of Indian Penal Code and conviction is already recorded of the balance plan, and therefore there is no question of spirit that the account will be of the here. What is it?
Yes.
Then in a case, where at the very initial stage, if a person comes for quashing the FIR on a settlement, although the offence is very hidden, in that case, the High Court can exercise that power.
No.
In a case, where charge is clear, but evidence is yet to be clean.
Now read paragraph, one paragraph we have skipped. Read sub paragraph 3 of the judgment of Narinder Singh and others. Sub paragraph 3. Loudly read it.
Other power is not to be exercised in those jurisdictions which involve heinous and serious offences of mental depravity or offences like murder, rape, tragedy, etc. Such offences are not private in nature and have a serious exercise. Similarly, for offences alleged to have been committed under
So this is a rider. All paragraphs is subject to paragraph 3. Isn't it? Now come to your judgment, recent judgment. Paragraph 15. This is not a ratio decidendi. People herein above are peculiar to the present case.
My lord, here, I have read the understanding.
we may say that your case is peculiar. May say, may not say also. But this is not a ratio. It is an order passed referring to paragraph 6 and 7 of the earlier judgment, but there is no discussions on paragraph 3,
Yes,
where it is specifically says in the same judgment that no, at any cost, this crime cannot be compromised. Now, subsequent to this judgment, there are 3 more judgments where specifically this was said that in case of rape, murder, no.
no.
Now, which will go by?
Now, here the only question around in this case,
376. And what is discussed?
Yes.
Paragraph 3 discussed. What is the answer to the paragraph 3 in this judgment?
Here,
Show us anything that paragraph 3 can be excluded. This judgment was,
in the judgment, the Supreme Court directly got that. Still the Supreme Court, here the Supreme Court say, other power is not.
so in that case, a guideline was laid. And in this case,
No, no.
relying on paragraph 2, in the peculiar aspects of the case, Supreme Court passed an order. So this is not a ratio, this is a ratio.
This is the ratio. But here, the Supreme Court making this guideline, still the Supreme Court, in this case, in the London case, was that proceeding. Proceeding that is understanding principle, that is also equivalent to murder. The Supreme Court observed this.
Show me the paragraph where paragraph 3 of Narinder Singh is discussed.
Yes.
Or to say subsequent judgment of 2019. Narinder Singh is of 2014.
14.
Subsequent judgment of Lakshmi Narayan and Jagjit Singh is discussed.
And here, in this London case itself, after having clarified the legal position, the another approach we proceed to discuss the case at hand. There are 32 months.
So every case is decided on its own fact.
Here in the previous year.
Is that it?
Yes.
Yes.
Here,
Hmm.
the Supreme Court said, in earlier para, that the offense of murder, rape, robbery, these are serious and heinous offenses. And these are the offenses not against the individual, not against the society. So these are not court. And attempt to murder is also heinous and serious offense. That is not against.
But it is to be looked into whether it was injury was in a, whether case of 307 is made out.
But here, after clause 3,
Here specific case is that you entered at 12, raped her in absence of her husband.
after 6 days, she closed the affair. Firstly. Secondly, she did not even I do not know. So far, after 6 days, she did not also go for medical examination. So ultimately, if she has voluntarily entered, because it is a family matter. Here, in Kopil Gupta's case, if the victim girl, she launched the affair against a stranger, making the specific allegation that he raped her. This is a very specific allegation. Because the person is a stranger, on the pretext of giving a job to the victim, he came to her house, raped her, then affair was launched against him. And subsequently, she did not want to proceed with the prosecution because she is a young lady of 23 years. So she wanted to go ahead in her life, in her personal life, without going through the reform of a criminal, not going to the mental level of a criminal prosecution. So ultimately, she had that issue. So can that be less severe than the present case? I think no one. Because here, the sister-in-law making the allegation against the brother. The sister-in-law, she is having one child. After 6 days, she lost the affair. No medical examination. Now she is saying that under the influence of some outside people, she lost the affair due to misunderstanding. She doesn't want to continue the matter. Now, if the matter goes for trial, or if it for a moment, whether I think the trial goes to be based on the evidence of the prosecution. If the prosecution doesn't support the prosecution, argument is chance of equivalent case. So I think the work saying in this is two decision. The argument of the
Motion.
the ultimate object
Hmm,
of section 482 is to say
hmm.
either to prevent the abuse of process of code or security aims of justice. If by quashing this proceeding, a family harmony can be maintained, a family peace can be maintained. So ultimately, that is the greater interest, that is the aims of justice like that. Then have the better aims of justice, then continuing the proceeding in criminal court, and even pulling the witnesses and the even posting the payload.
You file an affidavit. Will not believe that affidavit. You file an affidavit here. 376, it's not. No, because whatever judgment we pass, that will have an impact on other cases. According to this court, the judgment you are relying on 2022, this is of my lord Judge Kapil Gupta's case. It was in a peculiar facts and circumstances of this case. And in this case, the judgments of Narinder Singh, the paragraph 3 is not discussed.
Yes.
Paragraph 3 is not discussed.
But subsequently,
In this case, the judgment where specific guideline is laid down in 2019 5 SCG 688 is not discussed. The judgment of the Honorable Apex Court in
again, in Dolmen Singh case, was 5 or 4. Was 5.
Hmm.
Was 3, 4, 5. What actually, I think it's forward the High Court is to examine as to whether the condition is remote and plain. And only
everything is subject to the condition number 3. Absolute bar. No, you cannot do in cases like this. Others are procedure what is to look which can be compromised, which is otherwise not non-compoundable under section 302. 302.
again, PS also, that has to be family.
What family rule? Brother-in-law will rape the sister-in-law. We cannot comment more than that. But you file an affidavit. Knowing something and law is different. Whatever judgment you pass will have a serious effect. Sorry to say, this judgment will have also effect. So we'll have to give clarification that this is not a ratio. This is not a ratio. Without any hesitation, we'll say this is in a peculiar facts and circumstances, this judgment is. Now, why we have asked him to file the affidavit? To look into whether a peculiar circumstances is made out in your case. But law is well settled, we cannot do this. And this judgment of Kapil Gupta is not a ratio. It is a fact decided. It is a law. It is a decision made on its own fact. The learned counsel for the respondent prays for and is granted 2 weeks time to file an affidavit. List accordingly.
Item 43.
That the judgment is passed in a peculiar facts of that case. Yes. Yes.
On the last page, the scanned copies of the lower court case was to be called for and the IO was to be present here. The successor IO, the original IO had filed the charge sheet. In that, the petitioner was found to have no evidence against her, but further
Item number
43.
43. Which order?
The order, my lord, 3rd of May 2023 of this court. The scanned copies of the lower court proceeding and the IO, the successor IO.
Where is the IO? No formal notice. Call for the scanned copies of the record. Public posting as some extra copy. The petitioner takes steps for service of notice upon respondent number 2 which is their post. Steps will be taken that list meet the method after 3 weeks.
No, it was not listed after 3 weeks. And the respondent number 2 is the inspector of police vigilance and anti-corruption who had, there were 2 cases lodged. One is in Gopur case by Dulal Bora, and one was on the basis of the commissioner of the government of Assam. And Pinaki Prasad Mishra, the inspector of police from the vigilance then, he filed an FIR, but the investigation was taken, both the cases were clubbed, and then the charge sheet was filed. And in the charge sheet, I'll take my lordship to the charge sheet.
In terms of office note dated 11/8/2023, notice in respect of respondent number 2 has not received back. So we'll have to have it, we send notice.
Because I'm a serving government officer, my promotion is due, and there is no materials against me that has been mentioned in the charge sheet. Further investigation was recommended by the IO, but not taken up by the SP.
What is under challenge here?
You know, the year 2006, so when I was holding temporary charge in a few months of the circle office dispute, there was a document application for settlement of land. Now, I did not have any power to settle the land, so I recommended it to the higher authority on the report of the Mandal. Now, against that, Mr. Dulal Bora lodged an FIR in Gorchuk police station, saying that I had settled the land. And my lordship knows that the division bench of this court has said that Mr. Dulal Bora has numerous occasions targeted government officials and tried to derail them from their careers. And I've annexed that order of my lordship. And since after due investigation, the IO after filing the...
You are enjoying a stay?
No,
There is a stay?
no, Lord. I'm just saying that I should be off the proceedings below, which is the PRC case. One of the main accused is now, I think...
Charge sheet starts at page 35.
Miller. And
Ends, what is the,
I bring my...
what is page 57?
Lord, I bring my lordship on that. There is 17Q at page 57. 17Q.
What is this? This is 70
Evidence collected against the
part of the search sheet.
part of the charge.
Yes, just kindly see 17Q and 17T.
So one thing,
He was the complainant. IO was Mr. Bordoloi.
Kindly see Mr. Das 17Q. Page 57
17Q.
and 17T.
17Q relates to me. 17P relates to some other option. And 17C also relates to me. 17P is the last line. This is for my lordship's attention.
Just a minute, I'm asking.
Wording in 17P will stop my lordship. The evidence was not allowed. You could not find it in the post here. I think that is why the scan prosecution for us. fact, he kept as an open-ended investigation by filing the crime. Without any
Now,
permission.
this is the search sheet. You are sent as an accused.
I have been listed as an accused.
Where is that?
Summons, no warrant, nothing against me.
Where is that, that you have been sent, again as an accused?
Below.
Page?
Is not, bring my lordship to that.
No,
No, in this search sheet, you are not an accused.
I've been listed
Two accused, Jamini Kolita Talukdar
as
and Dilip
accused,
Chandra
not-
Kolita.
Not proceeded against.
Huh?
They're accused, not proceeded against. I'll bring my lordship.
Not against them.
Particular, I'll bring my, column 11 at page 44. Column 11 at page 44.
Yes,
Particular, the accused person is not charged seated suspect. Accused number 1.
yes. So now what is your grievance?
No, my name is still on record and,
Where is that record? Where is the record?
scanned copy of the record has been called for by this court, not just before the.
I'm not
I should
getting
have
it.
been discharged.
You are not, you are
The
being,
case should have been closed against me with all these findings.
that is closed.
They have not closed it, they've kept it open.
Where is that?
As it appears from 17Q, last time you were can see, and efforts may be continued against the above named government servants. That is including you. So that number. Sumari Kobita Deka, Ratul Gurua, Ogeshwar Das.
Can it be done?
So that's it for subsection 8 of section 173. So that permits further investigation is not.
Further investigation permits subject to the court's permission.
The permission will that will not be required.
Now suppose what will happen if you, can you keep a person hanging like this? You have not collected any evidence. Are you continuing with the investigation? Forget about the court material. Whether you are still continuing with the evidence.
As it appears from 17Q.
I would draw my
Give us the status.
I would draw my lordship.
He said the heart, Mr. Swenso, learned counsel for the petitioner. The grievance of the petitioner is that though the petitioner has not been surcited in connection with the what is the case number? Not surcited in surcit number 03/2021 dated 6/7/2021 in connection with FIR. In connection with, give me the
FIR 7/2009.
Huh?
ACBPS case number
SCBPS case number
7/2019.
7/2019. Full stop. The perusal of the surcit, it is clear that the surcit was filed on 6/7/2021. 6/7/2021. The surcit further reveals that the evidence collected against the present petitioner and some other
Are not prosecutable yet.
reflects that the evidence so far collected against the present petitioner along with some others are not prosecutable evidence. Accordingly, the petitioner was not sent for trial. However, it was also observed in the case that efforts may continue against the present petitioner and some other government servants.
All retired.
Government servants, full stop. This is the offending provision according to the petitioner that for this observation, the petitioner's case for promotion has not been considered inasmuch as petitioner is still not aware whether such evidence, further evidence has been collected or investigation continued even after 2 years. That is, even after 2 years. Full stop. In that view of the matter,
The permission
the,
was not granted for competing with industry.
where is that?
That's why the scan.
Okay,
copy of the logo
okay.
report.
Okay. In the aforesaid backdrop, this court is of the view that the learned public prosecutor shall obtain an instruction whether any further investigation was carried out subsequent to filing of charge sheet in the case as discussed herein above, subsequent to 6/7/2021. Full stop. This court earlier called for the scanned copies of the case record. Same is also not received accordingly. Huh? According to you, no permission was given. And what remains?
My friend was saying about 173 and all, nothing is there.
You answer the file. From whom success?
Scan copy. Detailed scan copy from the-
No, no.
Sheets, okay, vulnerable whatever. This is final report. Thus, go through it. Go through it whether any permission was, I do not think permission is required, but
It doesn't say that.
you go through it on the next date, we'll take a call. In the meantime, you have a status report, whether present status. If you have not taken, proceeded with the investigation after 2 years, we'll make it clear that no further can be done and she should not be treated as an accused for any purpose.
A copy of this order.
7th of September.
A copy of this order may be there.
A copy of this order be furnished to Mr. Das Lanet Edition Committee. Accordingly,
Last time, this code, I'll have call for testing.
scan copies, nalagate, and the scan copies which is received. First of Mr. Das, additional public prosecutor, as a Mr. Swenso, learned counsel for the petitioner, may go through the same to address this court on the next date fix.
Some more than, serious more than.
Give a date, give a date, 15th of September.
If it's on a hearing day, we dispose of it.
Not necessary, any date we can dispose of it.
Request note is the copy of the local record, but there is only copy of my lordship. So if-
No, I have given a permission to go through it. Go through it and mark it, note it.
Like,
A copy of this order. Next.
Item number 44.
46. PN Chaudhary. Yes, Mr. Dasgupta, what is it?
If it was developed, referendum was indicated the criminal case under 420 IPC, and in that case, not was accused.
Hmm.
Despite that, not proceeding under 138 of the Legal Improvement Act
Hmm.
in Virginia.
Hmm.
That is a man. evidence in the provisions for it. Again, after elapse of 3 years time, it appears that this so far that evidence is concerned, the documents were not accepted. The relevant documents were not accepted. Only those documents were annexed. Now the learned court was of the view that it is an inadvertent mistake, it can be rectified. And thereafter, it was allowed to be rectified. We also prefer a revision. And the session leaders of the view, can be rectified.
Same is the view here. Same is the view here.
Rectified. Anyway, because that is a case, debatable issue that this can be rectified or not. Second year was of the view, after going through section 461 of CAS. And if you go through the section 461 of CAS, I think the subject to what your lordship said. And now not super, if your lordship goes to the ground, so I have to get some cases. Page 50, RD.
This is motion or admission? Huh? Quashment motion. No notice has been issued till now.
No.
We are issuing a short notice. Art, Mr. So-and-so, Rana Senior Counsel, assisted by so-and-so. Present application filed under section 488, 482 of the Criminal Procedure to quash a proceeding under section 138 of the Negotiable Instrument Act. Mr. Dasgupta argues that vital issue involved in this case to the effect that whether on dishonor of sex, 2 criminal cases, that is under section 138 of the NI Act 1881, and other offense of sitting containing section 420 of IPC is permitted to be allowed. It is further case of the petitioner that the complainant were allowed to correct certain mistake of non-exhibiting documents. Issue notice returnable on given date. 29th of September 2023. The proceeding before the court may proceed, however, the same will be subject to outcome of this.
45.
Yes, Khan. Huh? And then where is that? Yes.
Yes. 59 versus 29.
Where is the complaint? Where is the complaint? Huh?
Yes.
Your accused number? Please this matter along issue notice returnable. What is the order? Earlier order? Yes. See it. Mr. Khan decision criminal petitions under second so assailing so. The said complaint petition has also been assailed by some other accused person in criminal petition number 782/2023, and this court under its order dated 3/8/2023 has already stayed the further proceeding of the criminal case within bracket warrant number 20/2020 and the order dated 2/6/2023 and all subsequent orders pending before the learned additional CJM Bongaigaon. Full stop. In that view of the matter, this matter be tagged along with the aforesaid criminal petition after return of notice. Steps within 5 days.
Item 46.
Yes. Mr. Chaudhary. What is that? Returnable after 6 weeks fully given. Yes, yes, Mr. Chaudhary. Binoy Babu Sinha.
The same point by that. Here the criminal one petition by the another petition. That would be pending to be someone.
Pending since when?
What is criminal division petition 144?
16 to 2022.
It's preferred by CBI. That case kind of trial court is allowed. In our case, kind of approval. Is getting the same other according to the.
Case 46.
Other.
What is the law in this regard?
All is not against us.
Then, as this is and that.
But decision only thing by law. Whether our by law, parliament is violated. Does not give my discount.
But that they will discuss when time comes. It is will be binding upon us.
That would be obviously income.
We'll take this matter on Monday. What is the next date?
Next date is
On
Fourth.
4. Monday is a holiday, I think.
Monday is holiday now.
28. We'll take it on 28. Give me the judgment.
Monday.
Let me also have, because I was surprised that motions are also given in this question. Tell them that it should be, motion will be in motion column. These questions, all pending questions which are pending are directed to be listed. All postmental motion will not include here. Orders, admission, hearing, everything will come under this. Those who are seeking postman. But motion will be in the motion series because motion will come with preparation. Others, because we should not come with our own set of minds. We should be open. Okay, that is case. Okay, list this matter on 28 in the motion column.
Item 47.
Yes, what is this? For a fire crossing, where is that?
FIR is on,
Page 28.
yes, sir. Fact, if you allow me to read the FIR,
Yes, ma'am. Where is? Yes.
it's not, it's for, 18 years.
18.
FIR on extortion by SRP and OCGRP court. Respected sir, with reference to the above subject, I have the honor to inform you and seek justice on the basis of that detail below. I boarded on Rajdhani Express dated 22/03, the 3 has been released 2013 ex Guwahati to New Delhi. At Guwahati station, my baggage was checked inside the train, coach in which the GRV patrolling party found a signal car, which is not armed, without groups purchased by me for my grandson through Mr. Bhobo Kolita, Secretary Shooting Range, Assam Rifles, and the same can be confirmed from him. I was forced to cancel my travel and was taken to GRP police station, Guwahati railway station, where I was abused and assaulted by the OC GRP, Mr. Shubhajyoti Hazarika, SI, acting in an instance of Mr. Ronak Ali Hazarika, the SRP. The signal gun was seized and has not been returned yet. After my repeated request to OC GRP that it is not armed and ammunition, but a signal gun purchased for my grandson from Mr. Bhobo Kolita, I was not listened to and was threatened that since I was carrying arms and ammunition, I would be sent to jail. Mr. Bhobo Kolita spoke to the OC GRP that and also Mr. Pallab Bhattacharjee, IPS ADGP, Special Branch Kandipara, Guwahati, and informed them that it was a signal gun. Mr. Bhobo Kolita also sent a person to the GRP police station to confirm the same. But still, after confirming the same from Mr. Bhobo Kolita, the OC GRP didn't release. Finally, OC GRP demanded a bribe of ₹8 lakhs on behalf of SRP and an Apple iPad for ₹50,000 for himself. That's the allegation of it. On that day, there was some function of the meeting of the Assam Police Department told to me by the OC GRP, due to whom the SRP came to the GRP police station, Guwahati railway station in the evening. Finally, ₹5 lakhs were extorted from me by the SRP and an Apple iPad for ₹50,000 by the OC GRP. Then I was released at late night. I was also treated by the SRP and the OC GRP that I will have to face the consequences if I report the matter to higher authority. After 1 month of the incident, I again came to Guwahati and then Mr. Bhobo Kolita and myself made Mr. Pallab Bhattacharjee, IPS, ADGP, so and narrated the entire incident. I had given a statement to the then GIG CID in charge of GRP, Sri Anurag Agarwal, IPS, in writing. However, no action has been taken so far. I request you to inquire about the properties of Mr. Ronak Ali Hazarika and Mr. Shubhajyoti Hazarika, as they are extorting money and misbehaving with innocent people by fabricating false evidence and misusing their power. Significantly, we have learned from reliable sources that the signal gun was sent to FSL for seeking opinion, and the FSL testified the gun as a signal gun. Sir, I would like to bring to your kind notice that such illegal activities of the GRP at Guwahati railway station is very common, and many innocent people are victims of police atrocity and illegal demand of bribes. So, I am willing to provide support and evidence to the department to stop such illegal activities. I therefore request your honor to take up proper investigation. Your here, my point of assay in the FIR is the date of the incident. The date of the incident is 22/03/2013. And it was reported to facts to the CID on 07
What is the date of incident?
22/03/2013.
After 3 years.
About more than 3 years. And interestingly, as you know, your lordship, the charge has been filed after 6 years without condoning the delay.
Search it file.
Yes, sir, sir. Cognizance taken.
Cognizance taken, he challenged the cognizance on the ground of sanction. That was dismissed by.
Not only ground of sanction, on the delaying.
So that has been dismissed by this court.
Sanction has been held to be valid by the citizen judge,
Additional citizen.
additional citizen judge, and now he has come against the charge.
That's it, FIR.
Assemble up to, not a case. If everything is done, already will not reverse the clock. Allegations are serious. Allegations are according to us serious. If you harass a person like this.
And delay is not the ground, 468.
Zero
will come into
Yeah.
place. Delay is no ground.
Anyway, at to.
Particularly when he is not IPS officer.
We'll hear at to.
This particular FIR is time burden on your limitation period. It is one of the points. Second, your lordship, thus, charge sheet is submitted for 6 long years. 6 long years, and in the charge sheet, your lordship, you see your lordship, the possible change has been banned, has been allowed, record. So page number 38.
Page 38. Yes.
Carry up with it. The competent authority was moved to record center for prosecution of activity, normally IPS. Then SRP Pandu in connection with another case December so under section 384 IPC. Accordingly, secretary to the government of Assam school quality according sanction to prosecute accused. So normally IPS for offense under so as per provision of section 197 of CRPC conveyed by memo number so. Dated 2/9/2021. There's no date of application when the application was made for to get a procedural sanction. And it has not been mentioned in any of the orders passed by this passed by the honorable court below in taking cognizance. And your lordship, I want to bring to your notice, your lordship. Page number 52. That is the cognizance took by the DMFC, which was taken on 7/11/2021. Case report received on transfer from disposal. There is the same cognizance of offense under section 384 of IPC is hereby taken against the accused person. Namely, Honorable Elegant Subhajit Aditya, send the city for copy to summons to accused person. There is nothing regarding the delay, your lordship. Not even the charge sheet, nor in the filing of the FIR, your lordship, on convolution of delay or why the delay was so extraordinary or so long, your lordship. And in the future, your lordship, that could be your honors decision to be viewed in the admitting institution because it's a pure case of abuse of process of the honorable court, your lordship. Because the incident took place long back 2013, and it was taken notice of on the date 7/10/2016. Although in the FIR itself it is averted and it is prima facie available that from the date of incident after one month he came back again to Guwahati. but he never bothered to file any FIR or any criminal case in the honorable court below under section 200 or FIR on under 54.
Yes. Yes.
It's a big case, Your Lordship, from my vision, Your Lordship, that this case can be appealed and allow me to present this case before Your Honor, after getting the records from the lower court, Your Lordship.
Yes,
Only then Your Lordship will be able to justify that whether the convolution of today has been late or not. It's a part and parcel of the lower court below.
What is the period of delay prescribed?
What is-
There are period of delay prescribed that FIR should be filed within this period.
Your Lordship, there is nothing written regarding the period of delay filing the FIR. But there's a enforcing a limitation, Your Lordship, that is cognizance should not be taken after such and such period as per mentioned in 1 and 1.
Under which provision?
Your Lordship, 468. Section 1, 468. 1. 1C.
4.
1C. And 473, Your Lordship, the same sector, Your Lordship. It is specifically mentioned, Your Lordship, that the period of limitation, if it is satisfied in the facts and in the circumstances of the case that the delay has been properly explained, or that it is necessary so to do in the interest of justice.
What is the punishment of under
3 years.
section 384?
Up to 3 years. Up to 3 years. And the period of filing the charge sheet is 6 months maximum. 6 months. And there is nothing in the charge sheet asking the honorable court below to only.
What is the punishment under 384? Cognizance taken under 384.
Yes, sir.
What is the punishment of 384?
3 years, Your Lordship. 3 years. Maximum 3 years. And Your Lordship, the allegation is made, someone has demanded money on my behalf. That is the allegation.
No. At your instigation, he was.
Nothing you can seize, not even the iPad, was it in the source of allegation here from the OC. There is nothing in the subsidiary.
Yes.
My humble submission, police, I would go to the catalog judgment, Your Lordship, which allows the honorable court to use its power under section 4 to quash this particular FIR along with the charge. And those are, Your Lordship, case process to Haryana, case of Haryana versus Badalal in 1982. And Your Lordship, there are some others, Your Lordship. R.P. Kapoor versus State of Punjab. And so, Your Lordship, so when it has been specifically mentioned that Your Lordship, criminal proceeding, if the criminal proceeding in question is in respect of an offence alleged to have been committed by an accused person, and if penibly appears that there is a legal bar against the institution of or continuation of the said proceeding, the High Court would be justified in passing the proceeding on the ground by excluding the inherent power of the High Court. And the bar is, Your Lordship, under section 468 1C, Your Lordship. That is the bar.
Bar is under 468 2C.
1C. sorry, zero, so, my mistake. 2
to see.
Kindly call for the record from the court below, Your Lordship.
Yes, thus. 3 years from what?
From the date of offense, Your Lordship, and the, no, that is, yes, yes. It has been
Kindly
included.
show us that 3
Your
years.
Lordship, it is included in the, in section 469 that commencement of period of limitation, Your Lordship. The period of limitation in relation to an offender shall commence on the date of the offense. That is A. B. Where the commission of the offense was not known to the person agreed by the offense or to any police officer, the first day on which such offense comes to the knowledge of such person or to any police officer, whichever is earlier. C. Where it is not known by whom the officer offense was committed, the first day on which the identity of the offender is known to the person agreed by the offense or to the police officer making investigation into the offense, whichever is earlier. Here, Your Lordship, from the day of the incident, the informant know the offender and delayed, and but he never bothered. And in fact, he came back again to Guwahati after 1 month. 1 month, which has been written in the FIR, that he met the then IGP Mr. Bhattacharjee. He has been written in FIR. If I took you the FIR. Mr. Pobo, he is the one 19, para number 3. Pobo police spoke to OCDRP that, and also Mr. Paulo Bhattacharjee, ADG special branch. Page number 20, second para. After 1 month of the incident, I again came to Guwahati and then Mr. Bhattacharjee and myself made Mr. Paulo Bhattacharjee, IPS, ADGP, SB branch and narrated the entire incident. I had given a statement to the then GIP CID in charge of GIP, Chief Anurag Agarwal IPS, in writing. However, no action has been taken so far. That means he had the knowledge regarding the offender.
Yes.
As it is. But he never bothered to take any step to bring the culprit into justice.
Yes, thus.
We are on to 60. Whether the 60 advisor is absolute law. Because in the time you worship, I don't want to put on your worship. He has rendered some explanation. And your worship will kindly see that offense is committed by the police officer and that to an IPS officer. Of the layman. And this person and your worship will find in the charge sheet the statements of statement of DGP also recorded. He telephonically this petitioner informed him that a twilight gun was this. I have to obtain facility. On this or that pretext, he was detained. He was made to pay bribe. So this is a serious.
Yes, all everything is serious. What is his argument is, how will you interpret 384 imprisonment for 3 years or fine or both? Suppose if it is both, then 3 years will not come. That limitation will not come because limitation is up to 3 years only,
That is not exceeding 3 years.
not exceeding 3 years.
Now, whether 3 years is inclusive or exclusive.
Now, if we interpret 384, that there is a possibility of not only imprisonment of 3 years, but both with fine.
Yes.
So fine is not included in this section, therefore limitation will not be applicable. That should be your argument.
Yes. And another argument is not
Because-
not exceeding the this is not exceeding 3 years. That means 2 years, 11 months, 2 years, 10 months.
That interpretation is already there.
These things will be there, but not 3 years. 3 years is not inclusive.
Okay, no, this is first time listed. Motion or what?
No, first,
Question first, motion. Motion, Quasman motion. Now what they have done is all Quasman's motion, everything is given in this. Okay, hard Mr. Wasim Rajal, under concept of petitioner. Who are the party is to notice returnable with
Already started looking to my London colleague. And along the relevant paper.
is to notice returnable after 4 weeks. At this stage, this court is not inclined to issue notice to the respondent number 2. However, same shall be considered after perusal of the scanned copies of the case diary. First of, accordingly, call for the scanned copies of the case diary. However, no interim order saying the proceeding is passed. Though it is made clear that
This petition will not be part.
no. This court, it is made clear that this court has not stayed the further proceeding of the so and so. However, same shall be subject to outcome of the present revision. Give a date. Court. Give a date. You come prepared on the next date. This will be an issue. 3 years and fine. But if suppose it is both, then it will be excluded.
Make any distinction regarding the fine.
We'll 482 will. So therefore, it is presumed that court has applied this mind, therefore limitation is not. What will be your interpretation? It says maximum 3 years or up to 3 years, something like that, not exceeding 3 years. So suppose if,
If it is 3 years, then.
okay, now suppose we refuse that argument also. There is a possibility of 3 years and fine. So and fine will not come under this. So limitation is not prepared. We'll interpret in that way. So be ready. That's why we should the notice. Otherwise, it's a case for dismissal. Yes.
Standing item 22,
What's the next step?
9th of October.
Yes. This is what is this? Huh? Yes, but how who is he? What is his role? Whether entitled for privilege?
Otherwise, you will also like kindly, I just like to point out only one thing. Here the FIR is blocked by one, for transport or allegation is that vehicle is supposed to be delivered from Dibrugarh to something to one Abhishek Kumar. But the present allegation is that the present accused person is able to mention the Abhishek Kumar taking over the vehicle, and thereafter the transferred it in the name of his wife, Manu. So these are the allegations. And during investigation, now from the affidavit manner, additional affidavit regarding his experience. Suppose he appeared by paragraph page 19, he is additional affidavit, paragraph number 4. Already, the vehicle, the original owner of the vehicle is one Dubodhar Bhai. And there is document that he sold this vehicle to one Abhishek on 16 to 20. And now the present accused person has transferred the name, the vehicle in the name of his wife on 6 to 20.
Impersonating him as Abhishek Kumar.
Yes, sir. He representing himself.
Okay.
And thereafter, during investigation,
Who lost this FIR? Abhishek Kumar.
Transporter.
Okay.
Who transport third party. Third party, that is, they are.
He transported the vehicle. He was to deliver to Abhishek. He said, I am the Abhishek Kumar.
Yes.
So he would good believe he handed over.
Yes.
Then he transferred it to his wife's name.
Quite someone was. Now in his additional affidavit, you know, the paragraph 4 that after purchasing the said general vehicle, it was brought to Goa Automobiles Private Limited for repairing, and after repairing the delivery of the vehicle was made on Iman by issuing date of assurance issued by the Goa Assurance. And thereafter the vehicle was registered on 6/23 at Saraido DPO office. But here, madam, during investigation, I found this is not, vehicle is not transferred at Saraido DPO office. Hodai, madam, DPO office. That my lord, report of the Hodai DPO is available, madam. And as per that report, that was my lord, vehicle name is transferred online verification. They are those, madam, that is.
Nowadays, it can be online only.
There is no any requirement for the passing physical evidence of the, so on the basis of the document that vehicle. Now from the investigation, there is nowhere, the original owner has he at any point of time sold this vehicle to the present accused madam.
What is the statement of the original owner?
Original owner, that is the.
He's Abhishek. He's sent to Abhishek. He's not Abhishek. Now give your explanation. What is your story? Tell us. Do you deny that vehicle is not registered in your wife's name?
No, I have submitted my lord to document.
Hmm.
My
No additional affidavit is here.
page 16, my lord. In my page 16.
Hmm.
My lord, transfer on 6/3/2020. Of the law.
Huh?
Of the law. 6/3/2023 was registered, transferred in the name of my wife, Monora.
Owner name Manohara.
Monora.
Registration is 28th of February 2021.
Yes, so original, it was registered
Hmm.
in the name of original Bailum, Dugantar Bailum, that is case 30.
Case
Case 30. It was registered on 20 February 2021.
20 to
It's the
22.
original registration,
Hmm.
and thereafter it is transferred in
Hmm.
the name of my wife, Monora Devam. She is on Sorai Devas.
But my lord, Saraido DPO has said that this vehicle is not transferred at DPO office. Saraido.
The document, this is the court document.
I do not know what is this document.
And also, so far, my lord, I submitted, I have also filed additional certificate that this damaged vehicle purchased by paying rupees 5 lakhs to one shopkeeper. His name is Ravi Kumar. Ravi Kumar is the agent of Abhishek Kumar. And Ravi Kumar received. And Ravi Kumar, Abhishek Kumar is the one group. And Ravi Kumar already received by of RTPS. And this RTPS also, my lord, I have enclosed in my additional affidavit at page 24.
That is DPO report. Designer. That vehicle was not transferred at the DPO.
And Abhishek, Ravi Kumar already been received this amount. And this, my lord, if based on this Jasper registration certificate, the honorable justice Amar Patel,
Don't take name of judges. We are courts.
coordinate court, pass order 10/5. By passing the
What is the affair, Mr.
FI number 8. There are one Nozmul Ali. Because they are saying, we are the Borval. The transportation in Northeast India, 3rd March
23. We transport 1 Kia Seltos car as well from River to Sansari on behalf of Mr. Abhishek Kumar. But one man, named Mr. Washim Rahman, has said that he is Abhishek
What is the
Kumar.
Abhishek Kumar statement? Kindly give us the Abhishek Kumar statement. It's vital. His statement is
He has
vital.
already taken demo of the vehicle. He has already.
What is his thing? Definitely his statement must be there. Because the transporters say, transporters problem is that we have been asked to deliver the vehicle to Abhishek Kumar. They delivered it to somebody else, so it is their fault. Abhishek Kumar will get hold of them. That's why they filed a FIR. Now, what is the statement of the Abhishek Kumar? If Abhishek Kumar says that,
Mr. Kumar has filed a demo application before the trial court and the vehicle.
and what is who is the original owner?
Original one, owner is one number, Bailung number,
By what is the statement of Bailung?
Bailung, Dudodhar Bailung.
What Bailung says that he has sold it to Manwara or he sold it to the Abhishek Kumar?
He is, as per note of the IO, IO has stated that Jugantar Bailung has stated that.
No, any statement of Jugantar Bailung. Two statements are vital. One is of Jugantar Bailung, other is of Abhishek Kumar. No, not note of the IO. Even because unnecessarily, suppose he has purchased it. If it is genuine, his document is genuine, why should we go inside? But if he has done this, then we will not consider, even if he is in interim, we will dismiss. We will come to that. Additional affidavit will see. Is it not the vital statement of the owner of the vehicle and the purchaser of the vehicle? According to the transporter, it was to be delivered to Abhishek Kumar. According to you, you have paid it to Bailung.
No, Abhishek Kumar. On behalf of Abhishek Kumar, Robi Kumar has 6 times.
Hmm.
I of RTL. Therefore, my decision. RTL to be 5 lakh.
So he might be cheated.
Already received. Robi Kumar. This is the RTL sold.
Okay, okay. The case diary, updated case diary be produced, which should include the statement of the original owner of the vehicle, namely Jugantar Bailung, and also the alleged purchaser of the vehicle, Abhishek Kumar and Abhishek Kumar. The petitioner also submits that he paid money to one Robi Kumar on behalf of the Abhishek Kumar. The case diary shall also incorporate the statement of the aforesaid Robi Kumar. And we first of the case diary be returned back for the aforesaid purpose and matter be listed on
He is on interim money from 29th of, 12th of October.
12th of October. In the meantime, interim order passed earlier shall continue and the petitioner may appear before the IO and produce the documents which he is relying on in the additional affidavit filed before this court. Original documents before the IO, on the basis of which he is claiming that he has in fact genuinely purchased the vehicle in the name of his wife.
1932.
Yes, that's huge quantity of recovered from his house, isn't it? He says that I purchase it and for the farmers. This is the case. So that isn't it? What the case there it says. The Caesar is there, no doubt about that. Caesar is there. Understand? Bottle.
These things are going on.
Not only that, because in those areas, this is case from which place? Roha. These are the places where huge cultivations are there and these diesels are required. Okay, considering the material allowed. Appear before you again. Get a statement recorded. Disposal.
Production list item number 1.
What is this production? Yes.
Identity to item number 8, that although it is the training.
Who are you?
I am number 2 because
In the hierarchy, having gone. Why have you not registered arms act?
This person wants to
No, no.
one mobile phone, one or two mobile phone.
He can also go.
Correctly, but if you lost it, just I can put in the case is.
Tell us if he is the same with the Mr. Mahajan's client. If it is the same footing.
Because
Okay,
from
same.
his position, only one mobile phone and some.
What will they do? Gun, what will do? What is the purpose of having gun training?
So for my instruction,
No.
they use air, these are all air guns.
What is the purpose of giving training? To save this country from China?
They use,
What is the purpose? Tell us first. To get bail. What is the purpose of having a gun training in a school field? I understand. What is the purpose of having trained to use air guns? Either to do a forest offense. Forest offense. You will kill the birds. If you are saying air guns, and to kill the mockingbirds, you want a training with air guns. Then for what we want to know? Why? Why you need a gun training? To kill whom? Or to do dacoity?
So far as my understanding,
Not understanding. You must have your knowledge. You are representing a client.
my knowledge,
Why your client participated in the air gun training? Tell us that.
my instruction is that for self-defense, this training.
Self-defense for what self-defense? Our state has not failed. Law and order is good. Huh? From whom you are self-defense? What self-defense? Tell us. We want to understand.
Nobody can predict accidentally.
So give guns to everybody and have a gun training to have self-defense. Or what?
I'm only a participant in the.
That's why I'm asking why you have participated to self-defense. What is the threat to your life? Tell us. Who are your threat? We'll get hold of them.
Not only physical training and this training of Lathi, bow and arrow, and air gun, there are other systems.
We'll say that this may be waging a war against the state. And so therefore offenses should be registered. Who knows, you may be regrouping to have a separate Assam. We'll ask in appropriate case to register cases waging war against the state. Because we have done training. Bow and arrow to kill whom? Huh? To kill whom? Bow and arrow? So there must be an investigation whether this is an investigation should go that whether this is an war against the state. What is the nobody may raise complaint. Will that legalize a training of training through guns, bows and arrows? That's why we want to know what is the purpose. Tell us.
My instruction is that it is for self-training.
Self-defense. Self-defense from whom? What is the self-defense?
Self-defense is like, nobody can predicate, accident, that is my submission.
So give guns to everybody. Everybody will have a, huh?
Obviously, my lord. That
And
can
have the result after 5 years. Huh? That people are, school students are gathering. Somebody will have a gun and kill the 20 students, like what is happening in some other countries where guns are being allowed. I am surprised why these cases are not registered under Arms Act and all. Why is not done? How a school can permit you to have this arms and ammunition training? Anything says, Mr. That
From his program, if you remember, the mobile phone was seized and one brown color and they
considering stage of detention and love. To the satisfaction of CGM Mohalde. Yes.
Item 51, stay matter.
Yes.
where the honorable was supposed to file this order.
Hmm.
2 weeks time.
Okay, the learned counsel for a respondent praise foreign is granted 2 weeks time to file objection. In, in any interim order? Interim order pass or test.
For admission, item number 10.
Yes.
Mediation is going on, my lord.
Oh, mediation is on.
Next date is fixed on 18th of September,
Okay.
my lord. So after 1 week at least.
Okay, it is submitted that the mediation is still going on in a positive way. To stop accordingly, the matter be listed
25th or
on 25th of September 2020.
online.
Item 11.
Yes,
I'm making prayer on behalf of faith for the Lionel Campus office. He informed me over telephone that his grandmother had cancer today early morning. Therefore, he could not stay.
okay. It is submitted that the learned arguing council is in bereavement. Accordingly, and a prayer for adjournment is made. To stop prayer is allowed. List this matter after. How can be 1 week? Many problems are rituals are there is Mr. Das. 1 week it will not be over. His grandmother expired. After we'll give 2009. Huh? Then this investigation is going on. Case record along with injury report. What to do then? 11th of September.
Item 12.
Operative party is 38.
This
Other
is,
part by London.
this is item number
12. Admission.
12. Admit all for the record. Issue notice. Returnable after 6/6. You have not filed any application. No application. No application. Appeal is certified by you that these are good grounds. Where is the affidavit? I was surprised. You give a certificate that these are good grounds. On what basis you will stay this? You file it. You file it. Appeal is admitted. Appeal is admitted. Yes.
Item 13.
Yes, Bothakur. On 1st of September. Release this matter on 1st of September. To get the report. We have an understanding that we will decide on 1st. In the meantime, whatever report is required, Bothakur will bring.
Item 14, along with production list item 2. Oh, earlier time.
Admit call for the record issue notice returnable on so and so in IA. As the connected appeal has already been appealed, applications of considered the material available on record, including the grounds of appeal. Full stop. Also consider the period of sentence, considering the matter in entirety, it is provided that the petitioner shall be allowed to remain on previous bail. Are you on previous bail? I stand this paper.
Item 15,
This is a conviction under so of 4 years. And the allegation is for the cricket ball entered into the shop. And the shopkeeper opened the tent of the boy and other friends did the pen has been opened. And that's the allegation. No sexual intent, nothing.
Where is the statement? So
You can also first see the statement under 164 at page 22.
page 22. Appellate लिखिए admit call for the record issue notice when LCR LCR and all. Page
Page 22.
this is the informant or victim.
Other has executed it here. Yesterday I was watching a Hindi movie, Rowdy Rathod. There also I have seen Akshay Kumar was sleeping inside the room, boys were playing outside. He followed all the boys inside and the boys were running out without their clothes. Then I was remembering this.
And then where is the deposition?
Because they are not-
What happened is he went inside. So he disturbed. Where?
There was exaggeration.
Where page.
Page 37. And we have put the contradictions. Yeah, first time. Because other people.
Page 37.
Other friends were also there. He developed his story, and in the cross, we have put it that this is not what we have stated in the 164, and we have also put it to the eye.
Heard Mr. B.D. Learned counsel for the petitioner. Also heard Mr. Plus additional. You want to file any objection here?
Oh,
Okay.
yes.
Okay. First up, considering the statement of the victim under the victim recorded under 164, as well as the deposition of the testimony of the victim given before the court, and the contradiction, and also the statement of the informant, the father, and his contradiction. This court is of the view that the petitioner has been able to make out a case for interference. Prima facie case. Prima facie case. In view of the aforesaid, the present, in view of the aforesaid, it is provided that till disposal of the connected appeal, the petitioner shall remain on previous bail.
But I'm inside the.
You are inside. A petitioner be released on bail. So and so to the satisfaction of the learned. Give the details in a note so that there is no mistake and you don't. Special just Boxo Tinsukia in connection with so and so case. Given. I stand this.
Time has changed. Our time will just come on. Other day also I find one Boxo case where neighbor kissed the small girl child. Mother has lost the Boxo case and the man is inside.
Yes, next.
Item 48 for hearing.
So these are very, very close time and so.
We have enough time.
Opinions without 886, and do it.
Hmm.
Judgment is now still fixed.
Maybe two witnesses. After reading two witnesses, we may say that acute. Or maybe after reading one witness, we may say that this is a case of conviction. So don't, more particularly in this court, don't say that it is a voluminous, it is having so many pages. We list, for us, these are least border things.
No, I'm saying, positive time.
It may take 15 minutes.
Okay, that is the length of idea at the moment. And incident book is 1989.
Mm.
Have prepared it written out.
Mm.
The convenience of your.
So we'll make it CAV. You have your written argument, 5 minutes.
No matter my argument is the same, my lord.
Yes.
Those large number of witnesses will have come in.
Mm.
Witness number.
What is the case about? Tell us first. What is the allegation against you?
Allegation is that, my lord. Okay, I will see. As many as 5 defined, my lord, FIR were lost. Paid way to be, my lord, CBI.
No, I'm not asking how many FIRs. I am asking what is the allegation.
I'm coming.
This is, we'll go in depth, but this is a bird's eye view. What is the allegation against you? First of all, who are you?
I'm the manager of bank.
You are a manager of bank.
Allegation-
What is the allegation against you?
Allegation is that there is a conspiracy,
Hmm.
taking place between me and other two
Hmm.
for committing forgery, cheating, and defalcation of the public fund.
Okay.
And the issue is that, my lord, there is some accounts were offered.
Hmm.
Whole allegation is that number of accounts were offered. That's not by me.
Hmm.
This is the only allegation. And other allegation is that, my lord,
Okay. So allegation is that you conspired with the other two accused
other two
and created forged accounts and siphon of the public money. This is the allegation.
is there.
Now, what are the evidences that they have proved?
And the evidence, my lord, so far as, my lord, my commission is concerned, my lord,
No, not your submission. Forget about everything.
every other.
We'll go to your submission a little bit later.
Hello, PW 6 and PW 35.
Who are they?
They are the official back.
Who are the star? They are the star witness for the prosecution. Okay. They are bank official. What is their evidence?
Bank official, they say, my lord.
Hmm.
Accounts are up to 5. Number 1, escalated by PW 35.
Okay.
Being a manager, he has nothing to do. They are supposed to, place their record, for relevant records, people is, manager and manager is two sides.
Hmm.
And, the person who introduced some fictitious person, there are as many as, 11 persons, but ultimately detected to be, and out of 11, 8 persons were detected to be, fictitious.
Hmm.
And one farm was detected to be fictitious.
Now, who withdrew this money? That fictitious accounts.
Those persons, those were fictitious persons, they allowed by submitting some false bill, which is called DD.
So according to the prosecution, what are the clinching evidences on the basis of which you have been convicted? According to prosecution, who are the star witnesses?
According to all the 3 persons are not involved.
No, involvement. Who are the star witnesses according to prosecution? On the basis of which the court believed that you have committed the wrong.
All them, most of their witnesses are relied upon by the court for belief, almost all them.
All the witnesses. There is no special star witnesses. No star witnesses.
According to him, my lord,
And what was the punishment?
punishment is 2 years
Hmm.
and 2,000, fine of 2,000.
2 years and 2,000. And conviction is against you or the other two also. And this is an appeal by,
By the manager.
and what about the other appeals?
Other thing is now as on the list that there is separate appeal.
This is here,
Yes, yes.
lawyer's name soon.
Correct. Yes.
You are also-
Supplementary disclosure.
Okay,
54.
this is by the other two,
One acre.
one accused. So total 3 accused. What about the other?
After that, I have one.
So that will be a difficulty. Yes, what is the other appeal number?
Other acre number. I have no idea.
One is 175, 2005. One is 149, 2005. Who, huh? Your one is 149. And there is 175. What about the other?
No, I don't know whether they have filed it or not. I have also not.
But you must have an idea. But see, suppose we are taking two appeals. One appeal is pending somewhere. That will be a difficult proposition. Mr. Prakash, you are always successful.
I rely on this court, but like it. I believe that law will help.
That is not a problem. But according to me, in my experience with you, you are always successful.
Always.
Successful. What to do?
It's because of that.
You have an instruction. The present appeal is preferred against judgment and conviction dated 17/5/2005
In special case number
in special case number
92/2005,
92/2005
corresponding to old case number
corresponding to old case number
15
15 within bracket C /89. By the aforesaid judgment, 3 persons were convicted. 2 appeals are listed before this court today. That is criminal appeal number 149/2005 and preferred by one Pranaranjan Bhattacharjee and criminal appeal number 175 of 2005 preferred by another accused, namely Mrityunjoy Ghosh. No, you are today unsuccessful. You are absolutely unsuccessful.
Argument is there, my lord, I am doing 8 marks. What witness?
And I think learned counsel for the CBI has not even gone into the brief.
No, I'm talking about it is only in a sort of only thing is the person that is helping. All the I also able to go through the answer.
And other is Madan Mohan Kundu
Yes.
and Mr. Prakash.
My lord.
You are also not briefed properly by Mr. Paul. You have not briefed properly. Everybody is saying we do not know about the second other case. It was filed by you, by 2 persons, Ms. Mrityunjoy Ghosh and Madan Mohan Kundu.
Yeah, our actually only by number 1, PN Bhattacharjee.
Okay. Okay, then all these orders are wrong.
Yeah.
And whose counsels names are shown? And in 175? It's Deka and Chakraborty.
And it's Roger Huya.
Huh?
Get it,
Give the. Hari Kara. Hari Kara. Very list number. Amaka service.
it's definitely.
Which is Deka? Aki Kolu. These two
are listed before this. For today, that is. Criminal 149 and criminal 175.
against judgment, so and so, so and so, so and so. Though Mr. Purokasta is ready to argue the matter in criminal appeal number 149 of 2005. However, none appears for the criminal appeal 175 of 2005. In such a situation, it will be difficult to proceed with the matter without any counsel. It will be difficult to proceed with the hearing in a background that the accused, two accused appellants in criminal appeal number 175 2005 shall be unrepresented. This matter is pending since the year 2005. Accordingly, this court requests Mr. Kaustubh Prakash Pathak, appoints Mr. Kaustubh Prakash Pathak as the no, this is son of KP Pathak. Kaustubh Prakash Pathak as an amicus curiae in this case. Kaustubh, list this matter on 27th of September. The paper book prepared, a copy of the paper book prepared by the registry, a paper book prepared be furnished to Mr. Kaustubh Prakash Pathak within a period of 3 days, and matter be listed for hearing on 27 too long. It will take some time. 19th of September 2023. So then 27th of September 2023, showing name of Mr. Kaustubh Prakash Pathak as amicus curiae. There are two paper books. Duta Keshwari ase,
এটা ভলিউম আছে
এগুলা judgment. So this duta volume eta volume.
ভলিউম 1 next to volume 2
I have also divided on composition of judgment.
Okay, that is there.
section of section
You make it. We cannot allow this 2005 matters to be pending. Mr. Das, what we are saying is Prokasta is always successful. He started with the voluminous cases. so many judgments.
Actually, my from itself state, I have seen the small cases not complete. Now these citizens are so holding up always.
And judges thinks that it will be difficult to better to avoid it. But this will not happen to this court. Howsoever voluminous.
On cases that are appear by law, because they appear by law, file about attending opposition 200.
See, he remembers that also. Yes,
So for 39 is concerned with that. He didn't speak. So this is my helping hand is not there. So all process.
okay, okay,
Some other thing.
okay. On the prayer of Mr. D. Das, Learned Additional Public Prosecutor, raise this matter on 28th of September.
Item 50.
Yes. Appeal against Equitel. Who is for the other side? Because it's appeal against Equitel. For the other side.
I try to complete.
Okay, what is the issue? Just tell us.
Yes. What has happened, Lord? The ambulance here is a businessman, Lord. He is scrap vehicles.
Hmm.
He, by auction purchase, he purchased 24 numbers of vehicles, 3 lots from ONGC now. And he authorized the accused, so far as 2 lots is concerned, Lord, consisting of 8 vehicles. He placed these condemned vehicles at 2 different places.
Hmm.
And the third lot was delivery was taken. He also authorized him to take the delivery. The third lot was delivery was taken by him, and it was again placed in the first place where the first lot, one of the lots. Thereafter, lot, what has the respondent lot slowly and gradually took the vehicles from there and lot sold it off to third party. This is the case.
Who is the affair?
So it's a complaint case.
Okay, it's a complaint case.
That's my indicate. Charge was framed under 468 and 409 because he has acted as an agent. And Lord, the trial court has granted conviction. And in appeal, Lord, he was, and we have a motion.
Okay. Who are your star witnesses? Where is the affair first? Let us see.
Complaint case,
Complaint is
Lord should take the paper.
paper.
Page 1 of the complaint.
One to 10. You are Pankaj Sharma.
Yes.
And the accuser Avtar Singh. Tara Singh. Yes, who is you are representing?
Actually, my lord, the main counsel is on his way.
Okay. Who is main counsel?
I am not sure myself. I just.
Yes. Hmm. Hmm. Page 2.
Complainant is contacted by occupation and also participates in option purchases. Complainant made offer to NSC. In response to tender notice, stated well, we are open and transparent. And the state tender was accepted by the integrated management. As rates lots mentioned in the state acceptance. In the present case, the complaint is concerned with lots number 395, 96, and 98.
Hmm.
With the activity note and the complaint.
Just a minute. 3 lots.
Yes, 395, 90.
Mr. Progasta, your amicus or 395, 396 and 398. Okay. Hmm.
The complaints before and to work for the complainant and this agent in auction purchase or taking delivery from the auction vendor and to do other work as per direction of the complaint. After receipt of the acceptance letter, the complainant received copy of the release from delivery order. It is 39,004 for lot number 398. My lord, see there are 3 different release orders. My lord.
Hmm.
Lot number 398 and so dated 28 for lot number 396. Both signed by manager of NBC. Then reason target to the DGM. With a copy to the complainant by letter dated 29/9/2004 to the general manager disposal. When this Sagar the complainant had authorized the accused to take delivery of the vehicles lot number 398 and 96 on his behalf. And his specific signature was also attested in the same letter. The vehicles of lot number 395 were listed by the complainant himself. The details of the vehicles of all the 3 lots are given in schedule A below. All the original acceptance letters and release from delivery orders were handed over to the accused, enable him to take delivery after retaining photocopies thereof, and they are in possession and if the accused has recovery and disposal of which facilities lifting of contained vehicles from the site where they were lying under the custody of any appointed, the accused took delivery of 8 number of vehicles of lot number 398 on 4/10/2004, and they were lifted from ONGC Sinamara.
Just a minute. 398 is on 410.
4/10,
4. Yes.
and they were lifted from ONGC Sinamara complex to the nearby link road at Jorhat Mariani, where from again they were taken to a site situated at NCLE Jorhat, belonging to Siraj Ali Ansari, Siraj Ansari, with the help of recovery van. The other 8 number of vehicles of lot number 396 were-
On 111.
Yes, ma'am.
395 also 111.
My lord. On 295 or 210, subsequently, with 2 lots, he took delivery,
Hmm.
98 and 96.
Hmm.
96 he took delivery on 111. We are lifted to the site situated in nearby Garbo Motors belonging to Zinvestor Purpose. These were put, 396 were put, place belonging to Zinvestor Purpose.
Hmm.
The complainant himself took delivery of 8 number of vehicles of lot number 395 on 2/10/2004, and they were also first lifted from ONGC Sinamara to nearby link road at Jorhat Mariani Road with the help of recovery van, and therefore to the site essentially at the same time. All the 24 vehicles of the 3 lots were removed by the accused to the respective sites with the help of his recovery van within a period of around 2 months after taking delivery from ONGC, and he entrusted the same 24 vehicles. The vehicles of lot number 398 and 396, which were lifted by the accused, were entrusted to him for keeping them in his custody. He kept the same in his custody as the site stated above. The vehicles of lot number 395 were also entrusted to the accused for keeping in his custody, and he kept in his custody the same site as principally lot. So two lots were kept at one place and one. That it was found with dishonest intention, the accused secretly negotiated the sale of the vehicle mentioned in Schedule B below and sold the same to different purchasers on or about 39,005. Also, accused sold the said vehicle as owner thereof, while in fact he was not the owner. He also signed the necessary prescribed forms for transfer of the vehicle by the DTO as owner thereof. He thus committed forgery with the intention to keep the complainant. He also committed criminal breach of trust in respect of the vehicle. He was entrusted fully to keep the vehicles in his custody. The accused dishonestly and illegally sold the vehicle as mentioned in Schedule B below and misappropriated the sale proceeds also. The other vehicles are not available at the site to which they are removed by the accused from the link road site of Jorat Mariani on being entrusted. That the vehicles mentioned in Schedule C has been sold by the accused by forging complainant's signature. That the remaining vehicle are not available at the site, and the same have been converted by the accused forging wrongful and illegal.
Who are the witnesses to prove this?
Complainant has been examined himself as
PW,
one manner
complainant.
and PW 1 and 2.
Any index in this paper book?
Yes, yes. My lord, we kindly come to the index. The second page is the index.
Okay, okay. So CW1, who is CW1?
PW is the complainant.
Complainant. Who is PW1?
PW 1 is my lord, the garage owner, my lord.
Uh,
Iraj Ansari.
Garage owner, which garage?
The first one, my lord, where 16 numbers of vehicles were placed. Lot number 395.
Vehicle under 395 and 396. Schedule B.
Yes.
Huh? Then who is PW2?
PW is investor of the other person.
That Garga Motors.
Yes, sir.
Then who is PW3?
Six days, my lord. Page
And who is PW3?
114 is the lot. Part of the judgment of the trial court, where the appendix has been. Where the-
Yes. Okay, okay, okay. Mashmi. Patla to this. Patla. Why PW7? Mon Nagaland official detail.
First, my lord, vehicles were first registered there, my lord.
Okay.
Some of the vehicles had different details, my lord. The registration number had been changed. In the digit numbers and were same, my lord.
What is basically the ground of conviction? On what evidence? Just summary. I do not think it will be over today.
Well, so far as conviction is concerned, but there is an admitted position that the vehicle he has acted as an agent.
Hmm.
The vehicles at the place of the
That is proved.
that is
according to the learned trial court. Then,
And not, you have to put 1 and 2 mirror, but the owners of this place they have also not given the evidence to the effect that from their place, the accused has taken away vehicles in part from the vehicle. But I was out of state in Dehradun, not at that point. And but so far as sense of 409 is concerned, the initial burden is on the customer prove that this has been entrusted. So once entrustment has been proved, Lord, then the burden shifts, whether it's been misappropriated or not. Here we have gone to a extent further to show that some of the vehicles, because the release orders under, some of them have been manipulated to show Avatar Singh or the respondent accused as the owner, and he signs documents as transferring them in the DTO. But some of the documents have been manipulated that the owner Pankaj Sharma has signed, whereas signature is his.
is it how it was proved?
He has also admitted one of his signatures in one of these documents. And from the records of the DTO also it has been shown, madam.
Sections alleged are 468
468,
and 409.
40.
468 relating to which are the documents that he has forged according to him. Which are the exhibits?
That exhibit 10 is a lot.
Exhibit 10. No, we'll
Yes,
go through that. Just want to have a overall view. Now, so exhibit, there is, it is first, it is to be proved that this you have purchased, Pankaj Sharma purchased it from the ONGC in an auction, in
Yes.
an auction.
Yes.
And the auction includes these vehicles.
Right, ma'am.
This part first is to be proved,
Yes.
this. Then the other Avatar Singh was the agent or employee of Pankaj Sharma. So it was, authority was given to him to put the vehicles in that place. Accordingly, he put it.
Right.
That part is also according to the trial court proved. Now, the question comes, what are the documents that this person has forged? These documents you have to identify.
Yes.
And if it is a forgery, how the forgery is proved that it is he who has committed or manufactured or forged the document. This is second part. Third part is that you were entrusted with the property already proved according to, or maybe is to be proved. Then, or however, he transferred it to his own use, the Schedule B vehicles, specifically those vehicles,
Yes.
not all the vehicles.
Yes.
This, how you have proved the second part that these vehicles he has transferred it or used it to his own use. That these will be the vital evidences. Instead of going to here and here all others,
Yes.
these will be the vital witnesses. And for that, what was the finding of the learned trial court? That is on which evidence this, according to the learned trial court, it is proved beyond reasonable doubt. This will be first. Second part is that why the appellate court disbelieved it, that this is not proved beyond reasonable doubt. Third part is, in a case of acquittal, to what extent we will exercise our power and what are the parameters to show that yes, even if there are two views, the views of the court acquitting
In favor of the
in favor of the
there is no
so basically these are the areas, boundaries areas we will be traveling.
Yes.
So let us start with in that way. If this complaint, I could understand that I am the as a businessman, these are the documents I have purchased it from ONGC. Mr. Avatar was my employee. I have given him authority letter, some I have taken. These were put in these areas. PW1, PW2, whosoever was having that plate, they said that yes, it was the Avatar who put it. Up to that, no problem. The second part will be important, that these vehicles were removed. Suppose that is also proved, that removal is for the purpose of his use of Avtar Singh, or it was fraudulently by manufacturing documents, it was transferred to other by none other than this Avtar Singh. This, if this is established, is gone. Yes. Yes.
One of the last proposals that we got, that they are if I burden is also not, if I can use the entrustment block, then further my
No, and that we understand, that you have given entrustment is true, but you will have to also prove that this has been,
yes, yes, but there are material things I can,
that will have to establish that I entrusted,
yes,
but also the fact that entrustment he has misused.
Yes.
Suppose I entrust something that has been stolen. Will it be a presumption that no, you are the person who stole it?
but in that case, not to see the interest rate,
Uh,
and then he must come with a reason what has happened.
Of
He
course.
is not responsible for that.
Okay.
That burden lies on him.
Okay, let us proceed in that way.
He will have to sign the picture of the one point. What the appellate has gone into, not, you of the appellate court is that the direction so far as use is concerned, put those vehicles at two places.
Hmm.
That is the end of the story for that. Nothing further has been dwelt regarding the evidence and materials on that.
So court said that it was his duty to put the vehicle there, he has put it. Now it is not his owners, it is the owner to look after this. Somebody steals this vehicle, it cannot be blamed upon you.
Appellate court, so far as what are the materials are concerned, that is the right for conviction. that has
So do
been
you
gone
say that this is a case of remand?
into- No, madam.
Okay.
This is case blood. Your lordship can,
There is also evidence for sure that he checked that vehicles are there. So it was not an exclusive dominion of the accused person. That is, yes, you prove. Heavy burden on him now.
Now let us see first the evidence of the complainant himself. Page 40.
yes,
I do not think today it will be over.
Well, that's why the state of the come out.
Oh, forget about seniors are, according to Justice, my brother, Justice Borua, they are daily wage earners.
let us see the scale of position I have, madam.
So, number one, this now Justice Borua has informed me today that no, that position has also been changed. Now they are hourly wage earners. So it's you will have to argue. We will not wait for any senior.
Not in our domain to make any comment as regards that.
In his case, around, you don't notice the office,
Hmm.
and you see the paper, who again, recently, and you see the boss. You can also, you see the paper.
This is a bad terminal.
Who again?
Let us see where is the cause this. Item number? Okay. Same.
No comment.
Okay. It is inheritance. In his case, it is inheritance. Yes, yes. But I'll have to appreciate that in a complaint case, beautifully drafted complaint. You'll have to appreciate. These days I am looking at all these complaint petitions, almost squashed, not less than 5 complaint cases. Yes, page 40.
Page 14.
ICR is here.
Hmm.
It's possible from the records. There will be some effect of here and there.
Okay, important.
Yeah.
Okay, Windows.
It is button.
In cross-examination part, there is something. And there's not much difference, a lot can verify from the record part.
Mr. Kamar,
Fine.
hope you are properly briefed yesterday.
Today we are in the opposite side.
That's why. Hope you are briefed properly, giving the material instructions.
Right.
Otherwise, at 3:30,
My life.
it's difficult without instruction.
I remember a lot of earlier comments that
Yes.
calling from. Daily to
You'll have to see the video later.
Nowadays, in 3 minutes is there.
My letter page 41.
Ah.
I filed the case against Karthi, Reliance Karthi. I know him since 4 or 5 years. I have left business. I also have some other business. This person on I and buy on option. Amnesty Limited is the sharing agent of NMDC. Mr. PC invites tender for old vehicle. I submitted tender and in May 2004 my tender was open. I became the highest tenderer. NMDC issued the acceptance letter of my tender. That acceptance letter contains the terms and conditions of the tender. There were 8 vehicles in a lot. The case is for 3 lots, lot number 395, 930, 23 numbers of vehicles, 24. Details are in the schedule of the complaint petition. I had deposited 18,80,000. This is the value of the entire lot, 3 lots. This is for 3 lots. After depositing the amount, NMDC issued release order. It was delivery from release order. Order was issued by the central sports manager. Release order was sent to BGM EP. A copy was given to me. For lot number 398, release order was issued on 39,004. For 96, it was issued on 28/10/2004. I gave authority to accuse on 29/9/2004. So this was the vehicles of lot number 396 and 98. That authority was addressed to the general manager disposal cell. Authority letter contains the specimen signature of the accused. I myself lifted the lot number 395 on 2/10/2004. After getting the authority letter, the accused lifted all the vehicles of both the lots on 4/10/2004 and 1/11/2004. Before this, the accused had done different works of NMDC with me. The accused has his own recovery hand. After taking delivery, the accused kept at the Sinamara complex of NMDC and by the side of the link road of Jorhat Mariani. I used to keep the damaged vehicles at that place. At first, the accused kept all the vehicles at the damages of Siraj Ansari and Siraj. But the accused kept 16 number of vehicles with Siraj Ansari. The remaining 8 vehicles were kept at the dump of Bimbes of Dastav. It took about 2-3 months to take vehicles from Sinamara to the dump. The accused kept the vehicles in them in his own arrangement. I allowed the accused to leave the vehicles and keep them. I told the accused that the vehicles will be sold after repairing. I never gave authority to the accused to sell the vehicles. At first, I saw the vehicles in the dump, but in the month of September, vehicles were not seen in the dump. I searched for the accused but could not find him. I told Viraj also to search for him. The accused sold all the vehicles. I could gather information where he sold 8 vehicles. I could not find out where he sold the rest of the vehicles. On visiting the office of DTO Jorhat, I found that the accused tried to transfer one vehicle by forging my signature, but the vehicle is not transferred till date. I went to DTO Mon Nagaland, Karbi Anglong, Simsagar, Diku, etc. to inquire. I came to know from these DTO officers that Avtar Singh sold the vehicles by putting his signature as the owner. He sold the vehicles as the owner, though he was not the real owner. The unfetched vehicles were sold by the accused. Exhibit 1 is the release order of lot number 395. I handed over the original release order of lot 396 and 98 to the accused, but those were not returned. Exhibit 11113 are my signature. As I gave authority to the accused to list vehicles of other two lots, those contain the specific signature of the accused. I have made ONGC.
What is this? Who is Suraj? What is who is
Sirajan.
Siraj Ansari?
Is the first business manager.
Okay.
I shall prove the release orders which are not received through ONGC. I know the accused since 3-4 years. There is no record of that. I do not have any record of that. My business is proprietorship. I do not make money to the accused. I used to give him goods, parts, etc. against his work. But this lot I have records before that I have given him parts against for that. I have engaged the accused for listing purpose. I have witness for that. We authorize the accused for listing from Cinema Complex. The accused put his signature in the sale form sold vehicles as the owner. I gave the vehicles on 537. I know Siraj Ansari in business terms. We use hire vehicles for Siraj Ansari on business purpose. We used to pay a part of our scrap material, Siraj in lieu of money. I have kept the lot number 395 after taking delivery personally at Mariani Link Road. For the remaining two lots, lot number 395 and 390, I have authorized accused to take delivery. I did not go there on the day Avatar Singh lifted the vehicle. Avatar Singh informed me that he lifted lot number 398 on 4/10/2004. Avatar Singh also informed me that lot number 396 was lifted on 1/11/4. I have not inquired when the vehicles were kept in PW2 and PW3. I was in Dehradun and Delhi. I went to Dehradun on 29/9/2009. I came back on September 2005. It may be last week of August also, I cannot recall it properly. I filed the case after 1 year of the incident. I have not said anything in the complaint petition regarding my stay in Dehradun for 1 year. I have not gone to police. I have not explained the delay. I have mentioned in the complaint petition, I have not permitted Avatar Singh to sell the vehicle. I have business relationship with Avatar Singh since 4-5 years. I have deposed on the complaint petition. In the examination in chief, I said I have not authorized Avatar Singh to sell the vehicle. Exhibit 22 is the attested copy of a letter written on pad to the GM ONGC original. Exhibit 22-1 is my signature. In that it was written as Pankaj Sharma, PR Road, Nehru Park, Bihar. Avatar Singh's signature was there. I know that I have that paid till now. It is not true that I have written any letter on my paid for starting on 5/11/2004. It is not true that I have given authority to Avatar Singh to sell the vehicles of lot number 20. It is not true that I put my signature and seal in that letter. It is not that my stay in Dehradun is released. I was there for a moment. The letter referring on 5/11/2004, these were also not produced, Millard. In cross, it was suggestion was put, Millard, whether he has given an authority to sell by this letter. I have authorized.
In cross-examination, they will argue,
My lord.
you have said that I have given of Avatar Singh on authority only to lift.
Yes.
Their interpretation will be that I have given authority to lift, so he has lifted. Where is the question of 44409?
Here, my lord, here the
That will be
suggestion.
their
Yes,
argument.
yes. I know the word will be coming from that side, but here, referring to this clause, the suggestion was put as if he has given an authority on 5/11.
Because their defense case is that you have given us authority to sell.
Yes.
You will contradict in that context, according to you, in that context, this cross-examination.
That suggestion
His-
is a
his-
very important.
Their case, according to you, their case is that he has sold it, but with authority.
No, Lord. Their case is, he has just put the vehicles there, not thereafter.
No, but they said, মই অবতার সিংহ মোৰ পেদত 5-11 চাৰিত কোনো ধৰণৰ চিঠি দিছিলো। সত্য নহয় যে চিঠিৰ লগত 398 গাড়ীৰ বিক্ৰীৰ authority দিছিলো। So that is their suggestion that you have not only given us the authority to lift,
My lord.
but also given authority to sell.
Therefore, Lord, this becomes very vital, Lord. The suggestion has come from their side, Lord. Where the defense has taken a plea that they have not done anything. Therefore, this is very relevant.
I have authorized Avatar to leave the vehicles. I have not written anything else. I had agreement with Avatar for leaving the vehicles. I do not remember the date when Avatar kept the vehicles. I gave the authority to Avatar for leaving the vehicles. It is not true that Avatar has not done forgery. It is not true that I have received money from Avatar for taking the vehicle. I do not have any written agreement with Avatar. It is not true that loss of rupees so and so is not occurred. It is not true that Avatar has not sold the vehicle. It is not true that I have filed a fraud.
Yes.
From page 45.
Hmm.
I know both the accused and the complainant have a garage and open space at Panchayali in October, November, December 2022. Avatar kept 16 vehicles in my garage. The vehicles were bought by recovery bank. The vehicles were kept for a lump sum of ₹10,000. In the month of August 2005, Avatar all the vehicles. I do not know where he took the vehicles. The vehicles were taken in the same condition as those there. I did not get the money. The complainant inquired about the vehicles in the month of December 2005. I know Avatar since last 15-20 years. He has a motor parts shop at Varali. He did not keep any vehicles before. The arrangement for keeping the vehicles in my case was done with Avatar.
But in Suraj, in his cross-examination, he says that I do not know to whom these vehicles belongs. Avatar Singh used to treat গাড়ীবোৰ Avatar Singh নিজে ৰাখিছিল লেনদেন তাৰ লগত মই গাড়ীবোৰ কাৰ নাজানো আগতেও তাৰ গাড়ী ৰাখে গাড়ী 16খন আছিল গাড়ীৰ নাম্বাৰবোৰ নাজানো Avatar Singh গাড়ীবোৰ ৰিকভাৰী ভানেৰে আনি আছিল and your statement is that you give Siraj vehicle rent in lieu of cash. You give scrap vehicles to him.
No, Avatar Singh, my lord.
No, to Siraj.
But that was pertaining to earlier deals I had with Siraj. This was an independent deal by the accused with Siraj. This has no relation to far as the complainant is concerned.
But the vehicles which were kept by
My lord.
this Avatar in Siraj's garage, according to Siraj, it is a dealing directly with Avatar. This is Avatar's vehicle in cross. Avatar's vehicle, and he taken where I do not know. He paid money for keeping. This is not my lookout.
Can you clarify over it was taken by Avatar?
Just we are not taking a final call.
No, no, sir.
I am just confronting with you with this.
Yes.
So if that be so, then a doubt is created whether the vehicles kept in Suraj's garage belongs to Avatar or Pankaj. A doubt is created
My lord,
by this cross.
let it be a doubt, my lord.
Okay.
I will resolve that doubt. But one thing has been established that the vehicles have been taken away by Avatar.
A vehicle has been taken away by Avatar Singh.
My lord.
This is admitted position.
Taken away, not taken in.
No, taken in is also there. See.
Taken in as the admitted position. I am one who have taken
গাড়ী
away.
থোৱাৰ বন্দোবস্ত মোৰ Avatar Singhৰ লগতহে and you say that some of the vehicles those who were misappropriated were kept in Suraj's Ansari's garage and Suraj Ansari I pay not in terms of cash but in terms of scrap since I am a scrap dealer. Now he says that those vehicles were kept in my garage.
Yes, my lord.
He is not saying that and this was the dealing was directly with Avatar. He confronts your witness, confronts your statement.
I am on blood on taking away the vehicle.
Vehicles has been taken away. But your whole case is that I have given authority to lift and keep the vehicle in this place. He has kept it. The place where vehicle is kept is one of your witness. And he is witness to prove that yes, I had a link with that my vehicles will be kept in your place and therefore I will pay you cash or whatsoever.
What he says is an independent deal with Avatar Singh. Let that confusion also is clear. Lord, and
Okay, just
But I am only on one point, Lord, that this establishes Lord, that from his garage,
Avatar Singh has taken away.
taken away the vehicle, and also a fact that a deal was with Avtar Singh and vehicle belongs to Avtar Singh. You cannot minus there.
My lord, may even take that formula, I have no difficulty.
Okay, okay.
My purpose is to demonstrate for your lordship that the vehicles have been taken away by him.
Vehicles were taken away by him. And according to your witness, that deal is with Avtar Singh. He is also having a business of motor parts, and he kept his vehicles kept. Okay. So according to your witness, Avtar Singh has taken away the vehicle which belongs to him, and deal is with directly to Avtar Singh.
That it should be clear further, my lord. I have no difficulty on that, my lord.
See, I have also limitation in criminal cases, so
Yes.
we will.
My friend has advantage, my lord. That's why the whole thing is prompted, sir. I have to be very cautious about it.
Yes,
I will see the cross, my lord. The vehicles were kept by Avtar Singh himself. The arrangement was made with him. I do not know who was the owner of the vehicle. I used to keep these vehicles. I do not know the number of the vehicle. Avtar Singh got the vehicle by him. The next witness is page 47. In this of doctor, I have a service
see,
station.
this also you have to read. Daribor Avtar Singh e nije rakhisil land and tar logot.
Yes, yes.
Moi Daribor kar najanu. Whereas the other, your claimant says that the deal is between him and me. আগতেও তার গাড়ি রাখলো মই 16খন আছিল গাড়ীবোৰৰ নাম্বাৰ নাজানো অৱতাৰ সিংহে গাড়ীবোৰ ৰিকভাৰী ভানেৰে আনিছিল okay now who is the PW3
That's not the.
who is he
But is the other cargo.
okay Gargo Motors okay
I have a service station at Tarajan. I have a 12-point repairing center with the garage. I have 15 acres of land. I know the accused is wrong. He has scrap business. He used to purchase vehicles in auction. The accused kept condemned vehicles in my place in 2004.
just a minute মোৰ আছে আসামিক চিনি পাওঁ বিশ্বপুৰা তেওঁ স্ক্ৰেপৰ কাৰবাৰ কৰে
He kept condemned vehicles in my place in 2004. When the NGC was written on the vehicle, he kept 8 vehicles with me for 8,000. The vehicles were towed by train. He took the vehicles in the month of August 2005. I do not know where he took the vehicle. He took the vehicle without repairing. He repaid the money as per the agreement. I know Pankaj Sharma since 15 years. Pankaj asked about the vehicles after those were removed.
so till the Pankaj asked that these vehicles are mine, the deal was with the Avtar.
And it was there.
Hmm?
It was there also.
Hmm.
I know Pankaj since 15 years. Pankaj asked about the vehicle after those were.
Okay. That is a sheep. Now come to cross.
The accused brought the vehicles one by one in November and December 2005. Pankaj asked me about the vehicles. He did not ask me anything else. Next week. I know Avtar Singh. I know the company, my residence. I have a 12-month repairing center. I have 6 acres of land. I do not know the DAR number, Patta number. My land is at Alhad Muta. There is garage in a part of my land. Agreement was made with Avtar. So right now, I have not signed over the agreement stamp for the money. It is not true that I have no land. It is not true that agreement was not made with me. Vehicles were not kept in my land. Pankaj was not present in the vehicle.
You committed a mistake. You have given all authority to him.
That I will demonstrate you, Lord.
Yes. Who is Haidar Ali?
But is the DPO.
Hmm.
Official of the.
The same.
Yes.
The DPO has deputed me to depose a witness in this case which I got.
Just a question.
My lord.
Are you in touch with your client?
Yes,
Okay. Because most of the cases, I've seen 2-3 cases, we have argued that no link.
No, my lord.
In some other cases. Okay.
If it continued for long, my lord, then probably. my lord,
Ah. Yes, proceed.
But this is a cancer patient. That's why I made a application for another.
Okay.
The DTO, if you have reputed vehicle, before the witness in this case with records, I was asked to bring the form number 2029 and the records regarding vehicle number 20. The chassis number of the vehicle number 20 is 20. Chassis number is 20. The vehicle was registered in the DTO office in the name of M.K. Agarwal. His address is 20. Originally, this vehicle was registered as number 20. The temporary address of M.K. Agarwal was Sheikh Nagar,
Is this vehicle
my lord.
reflected in your purchase vouchers from the ONGC? That this is vehicle purchased by you
Yes. So, because
in
there
the
are-
lot.
Yes.
It is under which 398, 395? Anything on that on record?
Yes. Let me see the schedule of my complaint.
Schedule of the complaint is prepared by you.
Yes, but I'll correlate with the release order and.
No, just a question.
Yes.
You purchase the vehicle in auction.
Yes.
Is in the auction, there is a list of number of the vehicles?
Yes. Yes, the chassis number, chassis number is,
Chassis number is,
no, number is.
okay. Okay, just for,
For an example, if I can put you.
no, just you proceed on your way. This is my bad habit that sometimes I put.
That's appreciable, my lord, when the answer is incorrect.
No, sometimes it happens, he's going in a flow.
I like.
No, but I also want the new blood, your purchase query should all first answer blood. That may come as a council, my lord, if I can cross the stumble, my lord, things become easier for me. Sir.
No, certain question comes into your mind while reading.
Yeah.
But this sometimes it creates a problem for the lawyer because his flow is,
The speed.
that is the problem, I know. But I do it, thereafter I realize, oh, I have committed mistake. Yes, proceed.
But our work becomes easier. My lord, is page 6 month.
Yes.
There we have given the schedule.
Okay, we'll come to the schedule later on. Now this DTO.
There are the
Hmm.
vehicle number is there.
Hmm.
Vehicle number is
Who
there.
is this N.K. Agarwal? Was he examined?
No,
Okay. He is the purchaser.
he is one of the purchasers.
One of the purchaser who purchased, whose vehicle was transferred in his name in DTO Difu.
Yes. M.K. Agarwala, B.K. Agarwala. Schedule A, lot 60 at page 6, lot number 398 has been. The registration number.
No, just let us first read this evidence. We'll come to that later. Later.
Your DQ has reputed with proposal witnessing case with record. You are asked to bring the form number 2029 and the records regarding vehicle number so and so. The chassis number of the vehicle number so and so is so and so. The vehicle was registered in the depot office in the name of M.K. Agarwal. Originally, this vehicle was registered as so and so, the temporary address. The registration was made on 1605 as a vehicle purchase on disposal at Nagaland. On 1/8/2005, the DTO recognized the no objection certificate and the basis of that no objection, M.K. Agarwal applied for registration and the registration was done by him. Exhibit 2 is the registration certificate issued by the DTO. Exhibit 3 is the vehicle tax receipt. in Nagaland.
Who signed this exhibit 3? No. Who signed this exhibit 9? Transfer. Because the DTO said that I do not know who sold the vehicle to N.K. Agarwal. But they have said that form number 27's photocopy. What those transfer vehicle to prove that it was, because except you, no one can transfer this vehicle?
Yes,
Because you are the authorized person who purchases in auction.
yes.
Now suppose vehicle is sold by somebody else, impersonating or forging your signature. Was that document exhibited? That forged document?
Yes.
How it was proved that it was done, signed by this man, or that this was not your signature? How was it proved?
One example I can give.
No, example, just knowledge, because today we cannot complete it.
My lord, in what has happened.
See,
Yes,
with my limited knowledge,
Trying to
your
explain.
case is that
My lord,
this man, I have asked him to keep my vehicles.
my lord.
I have purchased this pencil and asked him to keep it in this table. He took this vehicle without any authority and sold it to Jaul Kamar. And that selling and buying process requires an authentication.
Yes.
Then Jaul Kamar was not examined from whom he has purchased it. But the transfer through which this pencil was given to Jaul Kamar was sought to be proved. So there must be a transfer document. That transfer document was a photocopy document. Now your whole case is that this pencil can be sold only by you, not by anybody else.
Yes.
So therefore, the signature in the transfer document is not yours.
Not mine.
It is of the accused, Avtar. How it was proved? I want to know that.
But in one of the post documents, he has admitted that it is this thing. What has happened? But I mean,
So
my
the
explaining-
forgery is proved on admission,
Yes,
only admission,
yes.
no other.
But
That
all correlated evidences are there. But what was the modus operandi I indicate to you? This release
no,
order-
in a forgery, I think it should be shown that this is the document, this is the signature forged. This is not my signature.
Yes.
This is the signature of so and so, so and so. Your case will be that this signature he has admitted, so no proof is required. This is your case.
Yes.
Okay.
There are two modus operandi have been. In one of the release order, Lord, with the release order, if you lordship would see that the vehicles have been purchased by Pankaj Sharma. He has authorized the accused giving his specific signature that he can get the documents, get the vehicles released from there.
No problem up to that.
Lord, what has happened in one of the case, what he has done by getting the scan that ownership has been shown to the himself. That this-
How that is proved? That is what I want to know. This is the allegation. What he has done is that he scanned it, and how this alleged fact was proved beyond reasonable doubt. That is the evidence we require to convict a person.
Yes, yes, Father, that evidence is there on record.
Now, what is that evidence?
These are the evidence we looked at, which show that in one of the
Remind yourself and ourselves that we are in a case of acquittal
case of acquittal in appeal.
in appeal.
But I have no doubt on this, but I'm very much.
So that's why all these questions are coming.
Alert. I'll also rely on judgment that's later on.
A judgment when we are in a for me, when we are in a difficulty, that yes, we are confused. We need some help. Judgments are tuition masters.
Yes, that's true. Alert.
Yes.
There are documents, the record has been shown
Mm.
that Mr. X has purchased this vehicle from Avatar. Mr. X has even in his application, which has been part of record in the DTO office, saying that I have purchased from Avatar.
Okay.
Alert.
The person who purchased it,
Yes,
he was examined.
not examined, these documents are there in record in DTO. In the transfer, my lord, in the transfer application,
No, was it proved that this transfer document was signed by, it is the signature of Avtar Singh?
yes,
Was it proved?
and
How?
there are two more, but in one of those documents, he transferred the Pankaj Sharma, but signing of Avatar Singh.
Understand?
my lord.
Okay.
And the other one, my lord, he signs as owner of car saying he is transferring the name.
Now, how you presume that this is the accused who has done it, not by some third party?
My lord. If I can, therefore I was saying, lord.
That not the third party. Therefore, it will be required that have a specimen signature of Avtar Singh sent to FSL and compare with this signature and prove it. This is the way how a person can be convicted in the 468, according to me, subject to correction.
In order to prove forgery by which party? Forgery is to prove in that manner. The only by saying that I have forged will not do. That expert opinion has to come in manner in a forgery.
He says, suppose that is to be proved that this is the of his signature. Looking by the eyesight that this is the similar will not do in this kind of cases. Okay, some other day. Tomorrow, day after tomorrow, when?
So Monday.
Why is the Saturday?
No, you can. I am ready. I am ready to come for these cases.
Tomorrow is the holiday, but what's the holiday?
What holiday? We are thinking of giving up, asking the people to give list during puja vacation who are interested to dispose of their old cases. Give the list. And government will assure, public prosecutor will assure that they will have to come and give a list that will argue.
But all the beacons will go out.
We'll hear the shotguns and public amicus will appoint amicus. Yes, when? So we'll keep it as a part heard. It's a very old case. So these are, I think, the vital points.
Yes.
How many cases Monday? Who? Tuesday there is no scope.
Monday,
We try on Monday, my lord.
Monday 31. Tuesday 1 only. Huh? Huh? 15 minutes. Monday will be, what is the date? 14. Oh, we have fixed the repetition series by Dr. Ashok Saraf for this 19 meters.
No,
2029.
understanding that we can commit to the proceed.
Monday. Okay, we'll keep it on Monday. Jimmas are also Monday. Okay. Overbooked. And that too, close this.